with the consent of the petition, between item number 2 to 6, my lord. This matter be taken on 3rd of April. My lord. This AG is appearing, he will be late some. AG is appearing in this case.
That compassion matters.
That is also AG is appearing.
Correct, but I cannot do two.
Then let it. Let it be on 8, my lord. Then 8.
No, not 8. After vacation. After 8, that whole week will be motion week.
Let it be after vacation. The vacation.
Okay, on the prayer made on behalf of the AGSM, list the matter on
22nd, your lordship.
okay, 24th.
24th.
Thursday, lordship.
I have another payment, item number 13.
13.
Just now the petitioner filed a reply, my lord.
Yes.
Just now, I served it a reply just now, my lord. Let it come any other day, my lord. 13. The petitioner is here.
They file a reply when?
Just now. They filed a reply just now. I have been served a copy. My lord.
Okay. So when do you want?
Any after any next week, my lord. Any day.
Right. Mr. S. Bora, place for adjournment on the ground that the affidavit in reply has been served upon him just now. Accordingly, leave this matter after vacation.
Lordship.
After vacation.
May I please, your lordship. May I please, your lordship. I try to mention for listing of the registration for today, lordship. The urgency, lordship, the petitioner is a class 7 student of Jawaharlal Navoday Vidyalaya. Of class 7 of Jawaharlal Navoday Vidyalaya. And now a proposal is issued whereby it is stated that her admission will be cancelled today. And today is the last date of her examination, and she is asked to make her baggage and luggage, lordship.
No, when is the last date of examination? Today.
Today.
So she is going to finish her examination.
And she is asked to take her baggage after the examination, lordship.
So what is wrong with that?
Lordship, her admission cannot be cancelled because, lordship, a repetition, they filed a repetition. And in that repetition, this honorable court directed provisional admission. And also directed the state level caste scrutiny committee to determine the caste status of the petitioner. And that committee has not been formed till today, and no report has been submitted. And that is
tomorrow.
Lordship.
Tomorrow.
Lordship, she is given the provisional. In fact, the principal is saying that she would be given a provisional transfer certificate.
Provisional transfer can always be state tomorrow also.
Lordship.
Whether it's given today or tomorrow, how does it matter?
Lordship. Okay.
May it please, your lordship. In item number 12, my lord, there is another writ petition which was also tagged with the item number 12 and fixed today, my lord, but that was not come up. And both the writ petition the same.
We will see. Let it remain.
My lord.
There's nothing like that.
May I please, your lordship?
Yes.
Lordship, in item number 20, with the consent of the
Item number
20, lordship,
20. Yes.
with the consent of the other party, lordship, kindly allow us one day accommodation, lordship. Kindly
1 day
allow us
adjournment.
day accommodation, lordship. A.K. Pulkeshwar, council board petitioner, out of station, lordship.
Where is he gone?
He instructed me to
2018 matter. On the prayer for adjournment made on behalf of the A.K. Pulkeshwar. Just give me item 20. There have been adjourning the matter all the time, except for the last time. Except for the last time, petition has been adjourning all the time.
yes,
Why should I allow? You dispose of the matter.
my lord, kindly last chance, my lord.
Why last chance? Why?
Because there is some problem, my lord.
What problem? Your problem is you are adjourning the matter.
My lord, leave note also in the here, my lord. Serial number 20, my lord.
Right. Adjournment prayer has been made on behalf of the petitioner's counsel. It is seen that the petitioner has adjourned the matter on more than, on around 5 occasions earlier. On the prayer of the petitioner, lists the matter after 2 months. You can say after 3 months. No other.
If I may, my lord, I beg to mention an item for listing, writ petition for listing.
Huh?
My lord, I beg to mention a writ petition for listing, my lord, on 4th of April.
Registry.
My lord,
It's a pending matter.
yes, my lord.
Registry.
My lord, there's a urgency in this.
Maybe go to the registry. Go to the registry.
I didn't want for admission.
Maybe the lordship, so the petition for lordship for the area arrest. The petitioners were appointed as a teacher in the year 1999 lordship. After that, they were. Here, they have the basic training, and they received their skill pay.
Have you communicated with the client?
Lordship, I have communicated, I also filed one affidavit reply also, against the affidavit appointment. From 2012, they have not received any salary lordship,
Maybe.
but they are working in their SFE school from the date of their appointment lordship. After the pass out the basic trainings, they received the skill pay also lordship. And after that, they obtained the GPF amount account lordship.
But where is the undertaking given by them?
That is, we have not annexed in our.
Then?
But they have given an. Also, they received, accept,
Maybe, but then you challenge that. Where is that? Where have they said that?
but they have not, they have accepting the.
This is a 6th November 2023.
Filed the affidavit in the year 2024 lordship.
In your 2024, have you challenged your appointment? Then you leave your appointment. You leave your job. You leave your job.
On compulsion, they accept this lordship.
Correct. So you leave your job and you claim your arrear salary.
But that is. They were appointed in the year 1999. After that, they undergone the basic training.
Look,
They have, and after basic training, they already received a skill fellowship. And also they opened a GPF account.
where have you said that it was under compulsion and you are challenging this order?
No, they have not challenged this, their,
No. Have they said have you said in your affidavit that you did not make any undertaking that you will not claim the benefit?
affidavit stated that they were called by the director office to come to the Guwahati and give, the appointment letters issued to them on 31, 2021. And signature admit again.
So they are not adhering to it, Mr. Counsel.
My lord.
So if they are still pressing their claim, they are still pressing their claim.
Ma'am.
Then
Let them challenge the undertaking, my lord. They have,
where is the undertaking?
they have provided this. My lord.
Where is the
I'll
undertaking?
bring,
Where have they provided?
my lord, I'll bring, my lord.
You bring,
But they have given the undertaking, they will not collect.
show me that, no?
Man, I'll bring.
You bring that, you bring it today itself, we'll dispose it off.
They,
You can tell them to get you, to send it to you by WhatsApp.
next week, my lord, I'll bring.
Mr. P.K. Bora, Learned Counsel for the
Elementary education.
Elementary Education Department submits that the petitioners have been appointed, have been accommodated as teachers under illegal/irregular category on the condition that they would not claim any benefit in respect of past services rendered by them prior to 1/11/20, as per the direction of the government given by letter dated 21/1/2021. He submits that he will produce the undertaking given by the petitioners next week. List the matter on. I don't know, not Tuesday, but Tuesday might be a holiday. When?
On 11.
Not 11, that is all motion day, no, last day, no. You do it next week.
On 4th. On 4th, Lord.
Okay, 4th.
Obliged.
It's 7 to 9.
Your Lordship, last time BTC took time to obtain a copy of the meeting of minutes.
7 to 9. Yes,
Last time BTC took time to obtain a copy of the meeting of minutes of the committee Lordship.
yes, this is the one.
Lordship, may kindly peruse the third page, serial number 4.
Yes,
Your Lordship, the committee has opined that decision taken by the previous BTC government in regularizing the services of the above grade 3 and 4 employees does not bind the present government to follow the same. Lordship, here the BTC has decided not to pursue its previous policy decision to regularize the services of the petitioner. Lordship, may kindly grant us some time to.
Huh?
Lordship, may kindly grant us some time to bring the minutes of the meeting on record.
correct. Miss
S.A. Khalifa.
S
S.A. Khalifa.
appears for the petitioner, while Miss
H. Burrow on behalf of Mr. P. Nayak for BTC.
H. Borgohain appears on behalf of Mr. P. Nayak, Learned Counsel for the BTC. H. Barwa. She submits that in terms of the meeting minutes dated 9/1/2025, the petitioner's prayer for regularization has been rejected. She submits that she prays that she may be allowed to submit the meeting minutes dated 9/1/2025 in the form of an affidavit. Prayers allowed. She is accordingly granted
After delivery.
2 weeks time to file the affidavit. List the matter after the due beginning.
I think they.
He's got to put it in. No one appears for the petition on call. Ms. P. Das appears for the
1, 2, and 3.
respondent
Second.
112. The petitioner's case is that the petitioner's husband died in harness on 3/4/2001 while working as a grade 4 employee in the Katli Chera Girls High School. Hailakandi. The petitioner applied for compassionate appointment on 18/4/2001. Pusta. Instead of taking a decision on the petitioner's application for compassionate appointment, the headmistress of the school engaged the petitioner on 1/5/2001 as a grade 4 employee on the resolution of the managing committee. And since then, the petitioner has been serving in the school. The petitioner's case is that the petitioner's application for compassionate appointment not having been considered by the respondent authorities, even though the same had been forwarded to the Director of Secondary Education on 13/9/2004. By the Inspector of Schools, Hailakandi.
Annexure 5, page 16.
About the direction should be issued to the respondents to consider the petitioner's application for compassionate appointment. Full stop. Next para. Next para. It is the case of the respondent that the petitioner having been engaged as a grade 4 employee on 1/5/2001. Comma. There was no requirement of the petitioner being appointed on compassionate grounds, as the object of compassionate appointment had been met by engaging the petitioner. It is also the case of the respondent that the present case should be dismissed in view of more than 24 years having elapsed from the date of death of the petitioner's husband. In this regard, the respondent's counsel refers to the judgment of the Supreme Court in the case of Deborah Bata.
Devabrata.
What is that case number? In the case of Deborah Bata. Next para. In view of, no one appears for the petitioner, the writ petition is dismissed for non-prosecution. I am writing that so that when it comes next, we can see.
Item 11.
If you have placed.
I to the Lordship. Your Lordship, the grievance of the petitioner.
Item,
Item 11, Lordship. So although the petitioner is serving as a regular headmaster of a Miss School, Lordship, he is not allowed to draw the regular time scale of pay, number one. Second grievance is that from the date of suspension till the date of reinstatement, this period is not regularized, Lordship. These two grievance, Lordship.
he acquitted,
Lordship.
he was acquitted of the charges.
No,
No,
there is
he-
no criminal case, Lordship.
I mean, he was not found guilty, he was exonerated
Yes.
of the charges.
Lordship.
DP was held,
DP will.
but he was exonerated.
Reinstated.
Reinstated to, that's a different thing. You can be found guilty and still be reinstated. You see, because the punishment
One
need not
increment
have to be dismissal. It can be withholding of 1 increment, 2 increment, 3 increment.
one increment, which is.
So he was, penalty was given.
Yes, Lordship. So there, Lordship, after Lordship, the reinstatement, Lordship, the petitioner is not allowed to draw the regular time scale of pay, lordship. That is number one grievance. Second grievance is that from the date of suspension. illicit
Yes, madam. What is the penalty was with withdrawal of, withholding of
One increment.
one
lordship.
By
increment
stopping two increments, as per two increments.
on cumulative effect, with
No.
cumulative effect.
Point two, your lordship.
Yes.
Concluding departmental proceedings with penalty by stopping two increments, he was reinstated and posted as headmaster in Changmaji pre-senior madrasa by
Okay,
order
okay,
number
then-
so and so, but due to public obstacle, he could not join.
Okay, anyway, you see, the thing is that now he's asking for time
Scale.
scale of pay.
Pay.
Is he entitled to time scale of pay?
Pertaining to that, in this instruction, nothing has been disclosed, your
Please,
lordship.
so please obtain instruction. And another thing, the period between the suspension
Lordship.
and the reinstatement into service. Now, are you going to regularize that period or not? You have to take instructions. Okay,
In fact, lordship, they have submitted proposal.
for
regular,
regularization.
yes. That lordship will find it,
Okay, anyway, right.
yes.
Ms. P. Das shall obtain instructions with regard to whether the petitioner's service period, service break period between between his suspension and his reinstatement
That is, with effect from 3rd of February.
has been regularized. Who's bothered about the date? Pusta. The further question is whether the petition, the further instruction the Ms. P. Das shall obtain is with regard to the petitioner's claim for payment of time scale of pay. This is the matter when? After this is the matter after 3 weeks. To enable Ms. P. Das to obtain instructions.
That means
No hurry, 24.
20?
24.
24 matter. The other writ petitions. Pending is 2016-17.
Your lordship, pertaining to item 12, your lordship, instruction received, your lordship.
Yes.
And also one IA has been filed from our side, your lordship,
Okay.
respondent. And here, your lordship, I would like to refer page 5 of our IA.
Yes.
I would like to read it, that the applicant humbly begs to state that due to absence of any functioning SMDC of Daulatpur Higher Secondary School, the school is facing serious difficulty in running its affair. The activities of the school, such as PM Poshan, midday meal, and other activities are badly disrupted due to non-availability of SMDC, and the school is unable to pay the bills against the different activities. Under such circumstances, the present IA has been filed praying for modification, alteration, and vacation of the status quo, which order dated passed on dated 8/11/2024, and allows some officials of the department to act on behalf of the SMDC so as to smooth running of the affairs of the Daulatpur Higher Secondary School. Continuation to that, your lordship, I would like to draw your attention on paragraph 5, which is on page 6. I'd like to read it, that the applicant humbly begs to state that due to non-availability of SMDC, the midday meal and other activities of the school are badly disrupted, and the school is unable to pay the bills against the different activities. As such, this honorable court may be pleased to allow the block elementary officer, Bipuria, or inspector of school Lokhimpur to discharge the function of president of Daulatpur Higher Secondary School, your lordship. Due to your lordship, since March is ending, your lordship, all the funds will be go back. So in such a situation, your lordship, I has been filed, your lordship, kindly.
But you have not answered the issue. The only issue that you were supposed to answer was whether any notice had been issued to the petitioner?
Pertaining to that, your lordship, in the instruction itself, your lordship, it was clearly said that no notice was issued. For the
Then-
concerned
then-
SMDC prior to.
Then,
Even though your lordship, your lordship kindly direct the inspector of his school right now, your lordship, to take that financial charge, your lordship.
no,
And to vacate.
no, no, why
this-
should I? I'll tell the SMDC to take charge again, and let them pay the bills.
My lord,
Why should the inspector of schools take
my
charge?
lord. Matter is there, my lord.
You see, the thing is this. The SMDC,
This is the main party here, SMDC is.
maybe whoever, when you say, wherever you said that no notice was issued,
Your lordship,
Yes,
the
out
instruction
here.
itself.
it's there. So if no, that is their basic case.
My lord.
Their case is that the SMDC has been dissolved without issuing notice to them. And you have just said, yes, we did not issue notice. So the end of the matter.
Yes, my lord, that is correct.
Then end of the matter, nothing to do. Right. Right, mister?
May I, sir?
You are the one who wanted adjournment.
No, actually, what happened, my lord, I am not here.
You wanted adjournment this morning.
I want to check with the other matter first.
Yes, so I will, okay, I'll take it with the other matter. No, huh?
Dispose of this matter.
No, I'll take it with the other matter. That's what you wanted in the morning. Right, mister?
MAI Hussain.
MAI Hussain, Learned Counsel for the petition. Also heard who, Miss Pidas or Miss?
Her name may be there.
What, in the other matter, what is there? Same.
Same impugn order, my lord. Ground of challenge is the same, my lord.
By the same petitioner,
No, that is another school, man.
another school.
My lord. By the impugn order, two managing committee of two school has been dissolved.
Okay, right.
That will come up.
Anyway, that will come up. Miss P. Das appears for the secondary education department. That is respondents number 1, 2, and 3. Mr. P. Saiki appears for the respondent number 4. Okay, right. The, okay,
Resolution of the SMDC, there is a notification, madam. Earlier, one case is, I read yesterday, case was listed, madam. The notification said that, madam, initially after receiving the complaint, the concerned DO inspector had to conduct an inquiry. Madam. That after, on the basis of the inquiry, the SMDC can be dissolved. But then notification that doesn't say that 311 will be applicable. Madam.
Huh?
311, whether applicable or not, no matter whether notice have to be issued or not, that is not clear.
yes, please read, let us read the notification.
My lord.
What is not clear?
That notification, my lord, today.
Yes, let us,
Yesterday that matter.
let us see. Where is that notification?
Madam, this notification. This is only.
Notification dated 6/8/2014. Where is that?
14 month, yes.
Where is that 6/8/2014?
That was placed in the earlier occasions, my lord, and that was reflected in 6/12.
I know.
Order, my lord.
14 or nothing.
All the, regarding the resolution of school management and development committee, my lord, the clauses were inserted in that order, my lord.
You see, even if there is no notification, can you dissolve a school management committee without giving them an opportunity of hearing? It violates the principles of natural justice. Straight away.
That's my lord, true. And my lord, if inquired, my lord, he has heard, my lord,
Who?
that petitioner, if inquired, my lord, petitioner is heard by the.
So out here he said no notice was issued. When no notice is issued, how is the question of hearing?
But process of dissolution, that inspector have to conduct an inquiry.
That was also.
That to let them conduct, but then after they conduct the inquiry, they have to give them notice. This is the inquiry report I've made. What have you got to say about this? There's no dispute. Okay, whatever you say, let them make inquiry, no problem. Let them do anything, but at least hear them. That's all.
My lord, that part may be kept.
That,
open.
what part? Nothing is to be kept open.
Otherwise, my lord, the infirmity is there, my lord, that because he has already highlighted, my lord, what is the reason of the death resolution.
Okay, right. Right, the last order. Second paragraph, petitioner, who is the president, says so, Then third order, I'll just tick it. Paragraph, first, the second paragraph, third paragraph. Then this portion, clause 3 of the notification dated this portion, Next. Ms. Pidas, learned counsel for the secondary education, higher secondary, no,
Secondary.
secondary education department has submitted letter number so and so, dated 24/3/25, issued by the Inspector of Schools, Lakhimpur District Circle, North Lakhimpur, which states that no notice was issued to the concerned SMDC prior to dissolution. Yes, sir. The letter dated 24/3/2025 is made a part of the record and marked as an Annexure X. Okay. Next para. In view of the categorical, no, this, that. I have heard the counsel for the party. The contents of the letter dated 24/3/25 issued by the Inspector of Schools, Lakhimpur Circle, District Circle, North Lakhimpur, is reproduced here and below as follows. Here to here, red to red. Okay. First up, in view of the categorical stand taken by the respondents that the school managing committee had been dissolved without issuing any notice to them, this court is of the view that the said impugned order dated 9/10/2024 is not sustainable, as the same is in violation of the principles of natural justice. Accordingly, the impugned order dated 9/10/2024, by which the SMDC of the school has been dissolved, is hereby set aside. The writ petition is accordingly allowed. Then, in the main case, in the IA, right, in view of the order passed in the main case, the IA is dismissed. Okay, this letter also. Where is Miss Devi?
She is in court number 17, Lordship. Our item number is going on, Lordship.
Okay.
Court number 17.
Yes, and what has happened to this writ appeal?
Writ appeal, Lordship, on 4/3/2025, writ appeal is listed, but it was left out, Lordship.
It was not left out. It was adjourned by you.
No, Lordship.
Yes, I've got the order.
4/3/2025, writ appeal 171/2025 was listed before this honorable court, but it was left
Which
out.
one?
4/3/2025, writ appeal number 171/2025. It was left out.
It says in the order, as per the prayer of Miss K. Devi, the matter is adjourned.
But writ appeal is already pending.
Huh?
Writ appeal is pending because this.
Writ appeal is different. So the single bench judgment has not been stayed. So this case is also is also covered by the single bench judgment. What remains?
Let the matter listed along with writ appeal, Lordship. Let the matter may be taken along with writ appeal, Lordship.
Why? That is a writ appeal. That is a writ appeal, this is a writ petition. Why should we dismiss this case also?
Let me see.
It's a covered matter.
Let my senior come.
The covered matter, you go in writ appeal.
Let my senior come, Lordship.
What to do?
One chance may be given.
There, why you adjourning the matter before the writ appeal, before the writ court, before the appellate court?
We are not absorbing.
Yeah, I've got the order. Please bring out the order. That WA 171 or 187/23. WA 171/2023 or 187/2023.
Retapel is listed on 4/3/2025, 1/7/2025.
See.
To 2023.
Miss K. Devi at adjournment.
4/3/2025. Yes, I have seen it. Left out his signature.
Ah,
Left out his signature.
okay, left out. Okay, we'll give you the benefit of doubt for the time being, but next time, no benefit of doubt. I'm going to dispose of the matter. On the request of the counsel for the petitioner, list the matter in the first week of May. Yeah, I hope it's okay, May. You.
Please, your lordship, Mr. B. Chaudhary is on legs with a parted matter in court 10, your lordship. The matter after some time, your lordship.
Now, the problem here is the petitioners are not appearing. Basically, they have got everything except they have not got their, I think, their provident fund for which they were to go to the commissioner. There's nothing left in this case. End of the matter. Only problem is they're not coming, and then we have issued notice to them also. And the office note says that there is no return of AD card or unserved notice. What to do? Yeah, we'll fix it one more time just for there's nothing remains, I think. No one appears for the petition on call. Office note indicates that notice was issued to the petitioner by registered post with AD on 20/02/25. However, full stop. However, there is no return of AD card or unserved notice. That's all. List the matter. In the interest of justice, list the matter in May. May 1st. Give a date. Did I make notes last time? I don't remember. Where the way we are doing this case, this is the first time I'm doing a case like this. It is spread over so many months. Those are the notes. I'm confused in this case. Yes.
I can conclude this argument.
Huh?
I can conclude my argument to them.
Yes, I think something has to be done.
Yes.
I'm totally lost now again. Every time.
May I suggest something, Mila? Let us fix it on a date.
No, we are ready now, 11 o'clock.
Your lordship wants to hear, no problem.
I want to finish it up. I want to finish. Look, the thing is that the way we are going, I've lost interest also,
Yes, yes.
Where
yes.
are we? I don't remember what's going on, Every time we have got
That
to.
happens to this side also.
Look, that is also with me also. like,
Ah,
So may I
We-
suggest one thing, Mila? Let us have the Bihu, fix a date from Tuesday onwards, so that we can finish it one go. He has to finish, the other gentleman will
Where is
start.
Mr. Das?
Das will
Will be
start,
coming. He'll be coming, no?
Das will
Huh?
argue
But he'll be coming here.
the second case again.
Now we can hear, how long will you take?
That depends.
That is the problem.
No, no,
I'm
that
saying.
depends upon the cross examination to will by your lordship. Like. Otherwise, I will not take more than 1 hour time.
Okay, you do. Let us see what can be done.
Well, on
As-
that table,
as-
we have virtually we have finished the factual aspect.
Factual aspect.
To some
Factual aspect is in a nutshell.
very nutshell.
In a nutshell, it is basically to the effect that what was that?
Contract lever.
The pay scale that had been fixed had been made on the basis of his examining some of the workmen in the oil India. Correct.
Yes, yes.
And that workmen that he examined were workmen grade 4 and 5.
No, not yes, grade 4 and 5. No, actually, factual aspect is that whether the contract lever will get the same and similar weight, not salary, but same or similar weight as being performed by the regular one. That is the factual aspect. And the statute has this fixed an authority to decide whether they are performing same or similar job. And Deputy Labor Commissioner is the authority. And he had an occasion to make an inquiry in that. While conducting an inquiry, he examined a number of contract labor as well as a number of regular employees who are performing similar nature of job.
Just give me a citations, otherwise, what more submissions have you got to me?
No, I don't have any other submission. Only thing is that we are performing similar nature of job, and what the Deputy Labor Commissioner has done is perfectly all right. He has not given benefit to the extent where the regular employees are getting. Just he has enhanced some of our wages by this much. A portion of wage as being drawn by us was enhanced, not even at par with the regular employee. That is the factual aspect. Now, this aspect of this case was examined, was challenged by them by stating, by saying that we are covered by a settlement. We are covered by a settlement. And second aspect is that you cannot compare with the contract labor with the regular employee because their status is different. So you cannot compare. That is the sum and substance of their argument, as I have understood. That was
And the sum and substance of your argument is?
my sums are very simple, simpler than that. My sum and substance is that so far the wages payable to a contract labor and the regular employee is concerned, question of status is not pertinent. First thing. Second thing is that so far the settlements are concerned, it will not govern our case because of the fact there is a non-obstinate clause under section 30 of the Act. That is that on that day I have belovedly argued in this aspect. So far the settlements are concerned, this has no bearing on our wages. And so far the status is concerned, this has also no bearing in our cases, on our cases, because of the fact this rule make clear that if we perform same or similar nature of job as being performed by the regular employee, then our salary or wages, whatever you call it, may be same or similar to that extent. And the learned Deputy Labour Commissioner, after examining all aspects, that he came to a conclusion, yes, though their job contents are not identical, but it is same and similar. And so for that purpose, he has not enhanced our salary at par with the regular employee. He has simply enhanced our salary to some extent. And that aspect of this case is being challenged. So for that purpose, on that day, I have tried my best to refer those relevant provision. Relevant provision is section 30 of the Contract Labour Regulation Abolition Act. This is the relevant provision which will clarify entire aspect of this case. And Rule 25. In the Rule 25 is the how we what we differentiate this. Status or any other factors are not relevant. Only relevant factor is whether we are performing same or similar nature of job. I will try to pursue your lordship by referring those judgments, wherein this Supreme Court has categorically stated this is the only relevant factor.
How many judgments?
I will refer paragraph something. I get the
How many judgments?
I have got 10 judgment, but I will refer 8 judgment only. And that too by paragraphs. Only by referring paragraph. If we understand the law, then I don't think that it will take much time.
Okay, let us see.
Now, your lordship, come. Mas file running to the asylum.
This is the one. Oh, is this the one? No, this one. Yes.
Hmm.
This by the respondent number?
3. Now, your lordship, come to judgment number first 10.
Page 10.
No, page 10, no, page 98.
Page 98. So we're going to go backwards.
Yes, that is, of course, we should have been pushed.
That's not the normal way to read a book.
Yeah. Huh?
Page 98.
Yes. Bail workers.
Bell Workers Association.
Yes. that is the
Hardwar.
part. Yes. The only paragraph is 6.
Paragraph 6.
6. Relevant page is 104.
Yes.
Now, so for this rule 25, equal pay for equal. Thus, they have discussed, referred all these sections, relevant section, and after referring all these sections, Supreme Court was of the view that is reflected in paragraph 6. Thus, we see that no individuous distinction can be made against the contract labor. Contract labor is entitled to same wage, holidays, hours of work, and condition of service as are applicable to workmen directly employed by the principal employer of the establishment on the same and similar kind of work. That is the only thing is whether they are performing same or similar kind of work. They are entitled to recover their wages, their conditions of service, the same manner. That is not the relevant. Let me read. They are entitled to recover their wages and their condition of service in the same manner as the workers employed by the principal employer under the appropriate industrial labor laws. No. This is the point below. Now, your lordship, based on this point below, there are other judgments were delivered by the Supreme Court as well as the Kerala High Court, sorry, Madras High Court and Kerala High Court for you. Now, your lordship come to page 54 to 56, that item number 6.
If any dispute with,
Now,
if there is any dispute with regard to the type of work, the dispute has to be decided by the Chief Labor Commission.
yes. Here it is subsequently after this 80% it was amended. Now this authority has been vested to Deputy Labor Commission. At that point of time, when this judgment was delivered, the Chief Labor Commissioner was entrusted with. Subsequently, it has been vested with the Deputy Labor Commission. So he has to examine whether if there is any dispute, whether they are performing similar or same nature of jobs. And that is what has done in this case. Deputy Labor Commissioner has passed an order after examining the contract laborer as well as the regular employee. And while making his finding, he specifically stated, though they are not identical, but they are substantially they are same and similar. Now, my lord, come to page 54.
Para?
Page 54, that is a Supreme Court judgment, 2018-16 SCC, page 25. Para 5, 6, and 7. Page 54. Item number 6. But there is more elaboration, yes, this point. 54. Now, my lord, here, one point, my lord, whether the source of recruitment is essential factor.
Whether the
Source of recruitment, because the contract laborers are engaged by the contractor. Our regular employees are engaged by the employed by the principal employer through a recruitment process. So whether this recruitment process has any bearing in the case, so for the determination of the wage similar to detection.
has any bearing on the whether the recruitment process has any bearing on the
On the determination of the wages to be paid to the contract labor as the regular employee if they perform similar nature of job. Paragraph 5, 6, and 7. That is the Supreme Court judgment. Chemical. Let me read some lines. The distinction made and the finding recorded by the High Court on the basis of source of recruitment.
where are you reading? Which paragraph are you reading?
Sorry, paragraph 5.
Yes.
In this case,
Yes, yes, I've got it. Please read.
the distinction made and the finding recorded by the High Court on the basis of the source of recruitment also is not correct. There has to there has to be difference between the source for recruitment, even then, Rule 25 of the rules confers protection. That is the protection conferred by the Rule 25. Confers protection. As permanent employee have to be inducted by the employer by a different set of procedure. Whereas for worker employed by the contractor, the procedure of induction is bound to be different. Prima facie procedure protection is conferred on of similar wages to the employees engaged by a contractor. The impact of specific Rule 25 of the aforesaid rule and law in this regard has to be taken into consideration before coming to a conclusion. Paragraph 6.
No, this rule, what is this rule 25? Rule 25 of what?
That is the crux of the problem. Rule 25 is the Contract Labor Regulation and Abolition Act,
No.
whereby the Deputy Labor Commissioner was entrusted to determine whether the contract labor are performing the same or similar nature of job, and by making some inquiry as he deemed fit. And if he is satisfied that yes, they are performing same nature of job, then these types of differentiable context will not arise. Only thing is that he has to be satisfied whether they are performing. And if he is satisfied, then these things are not relevant. Now, paragraph 6 also mentioned the qualification aspect. Now, first aspect was the process of recruitment. Paragraph 6 is qualification. The qualification aspect vis-a-vis the provision, if any, in recruitment rules has not been discussed by the High Court in its judgment. There is no consideration of the qualification prescribed by in the two defined set of employees. Merely two employees possessing ITI certificate would not make any difference. Thus, the High Court should not have given finding and concluding the paragraph with respect to the qualification being defined without considering the qualification prescribed for two sets of defined employees. The observation that usually the workers employed by the contractor do not possess the grade. It is based on the assumption which was not warranted. Now, next judgment, I will refer. It is a judgment of Madras High Court probably. Your Lordship will find at page 43. Page 43, paragraph 16. Page 43, paragraph 16.
Paragraph 16, page 51.
Paragraph. Okay. Page 51, paragraph 16. Milord, I need not read the entire paragraph. I can just read out 2 or 3 lines. Same and similar occurring in Rule 25. Open without expressing any opinion. In our view, it is not possible to entertain the submission advance on behalf of the respondent that the said provision would apply only when the contract labor demonized that they were doing exactly same kind of work. Got it? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 line number. Or should I read the entire paragraph? It would be enough if the contract labor demonstrates that the work discharged by them was in connection with the work of the establishment, do any skilled, semi-skilled, unskilled supervisory, technical, clerical work and high work. The same and similar job is the essential here. Now we have another paragraph. Paragraph 7. That is it. All right, good. Now let me speak of this judgment. Let us come to another judgment. Here they want to say that exactly it need not be identical. That is why I refer this. But if it is same or similar, then the competent person authorized by the Act can exercise his jurisdiction.
This is a Bombay High Court judgment.
Yes, Bombay. The other judgment is probably Madras High Court judgment. This is item number 3. No. No, item number 5. Yes, page 43. It is gone. All right. Bombay High Court. Next one is in the Madras High Court judgment. That your lordship will find page 24 to 34. 24 to 34. Yes.
Sarah,
Para 8, 9, 11, 12. I'll 20, 24 to 34. The basic one issue, the status is not a factor when deciding a case under Rule 25A and B, A and B have to be. That is paragraph 8 and 9.
1, 2.
No.
Yes,
Page 24.
24. Yes,
That is the judgment of Madras High Court. Here all these points were considered substantially. And the judgment which I have referred at the very beginning, that judgment has also been considered, referred. No. Paragraph 8. Paragraph 8. Now, in the similar argument as argued by the other petitioner was argued in the Madras High Court. And the judgment, you all will find the judgment which was
this one.
no, the bulk of judgment. Yes. all these judgments, most of these judgments are also discussed here. And after discussing this judgment, the Honorable Madras High Court was of the view that these judgments are not at all relevant. Because of the fact guiding factor is Rule 25 and nothing else. That has been spelled out in paragraph 8. Page 31.
Paragraph 8 is at page 31. One.
It's a ভালো BSNL case, no? Got it?
Yes.
Now, the pronouncement made by the such and such, here all these judgments are referred. Starting from Randir Singh's equal pay for equal wages. About 25 or 26 judgments were referred. Now, after referring those judgments, the Honorable Madras High Court was of the opinion at paragraph 9. The judgments of the Honorable Apex Court do not deal with the similar situation on hand in which the employees concerned had approached the authority under the Contract Labor Regulation and Abolition Central Rules 1971. The issue on those cases was the fixation of pay between the casual and permanent employee. Casual and permanent employee. The issue has been raised directly either before the Central Administrative Tribunal or before the High Court, which ultimately ended before the Honorable Supreme Court. Therefore, this court is of the view that the sage judgment relied upon the learned counsel for the petitioner do not have any application to the case in hand. No, this is the finding made by the Supreme Court also, 2018 volume 14 SCC. Now, paragraph 11, in paragraph 11, that earlier judgment that I have referred at the very beginning, that was referred to and quoted. The provisions contained under Rule 25(5), paragraph 11, page 32.
No, I have got it.
Got it?
Yes.
The provisions contained under Rule 25(5) of the Contract Labor Regulation Abolition Central Rules 1971 makes it very clear that in a case where the workman concerned is employed by a contractor, perform the same or similar kind of work as the workman directly employed by the principal employer, then the benefits to such person shall be the same as applicable to the workman directly employed by the principal employer. Therefore, the said rule mandates that the benefits should be equal to both to a workman engaged by the contractor as against the workman engaged by the principal employer. Hence, considering the said provision coupled with the factual finding given by the first respondent, this court is of the view that the contention of the learned counsel for the petitioner cannot be accepted. Now, in Vale Workers Association, Haridwar versus such and such, 1980, of just now you put, I referred at the first item.
Yes.
That's right. Now, they have quoted section 5, paragraph 5 and paragraph 6. I only read out the paragraph 6. Let me read paragraph 5 if so required. Section 12, because paragraph 4 will give the little idea. Section 12 provides the licensing contractors. Section 13, 14, 15 provides for the grant of licenses, revocation, suspension, and amendment of license, appeal. Section 16 to 21 make detailed provision for the welfare of health of contract labor. Entire scheme. Section 20 of the particular provides that if any amenity required to be provided for the benefit of the contract labor employed in any establishment is not provided by the contractor within the prescribed time, such amenity shall be provided by the principal employer. Section 21 makes the contractor responsible for the payment of wages to each worker employed by him as contract labor, but the further prescribes that the principal employer shall nominate a representative duly authorized by him to be present at the time of disbursement of the wages by the contractor. Section 22 to 27 provide the penalties and procedure. Section 28 provides for the appointment of inspecting staff. Section 30 makes the provision of the effective provision that is very important. Just now I referred to Section 13 makes the provisions of an act effective, notwithstanding anything inconsistent therewith contained in any other law or in the terms of any agreement. Here's a settlement, etc. There, any agreement or contract of service of any standing orders applicable to the establishment. It, however, saves the contract labor any favorable benefits the contract labor may be entitled to under an agreement, contract, or service or standing order. Section 35 invests the appropriate government with the power to make rules for carrying out the purpose of this act. Rules made by the central government are required to be laid before the parliament for a total period of 30 days. In exercise of the power conferred under Section 35 of the Contract Labor Regulation and Abolition Act 1970, the central government has made the Contract Labor Regulation and Abolition Central Rules 1971. Chapter 2 of these rules relates to the matter pertaining to the Central Advisory Contract Labor Board, while Chapter 3 of the rules deals with the registration of the establishment and licensing of contractor. Rule 25, that is very, we are concerned. Rule 25 prescribes the form, terms, conditions of license. Rule 25(2)(5) prescribes that it shall be the condition of every license that the rates of wages shall not be less than the rates prescribed under the Minimum Wages Act 1948 for such employment where it is applicable, and where the rates have been fixed by the agreement, settlement or award, not less than the rates fixed such and such. In the case, now, there's a, let me skip to some extent, we can skip it off. Similarly, Rule 25(2)(5)(b), we are concerned with. Rule 25(2)(5)(b) provides that in other case where the wage, rates, holidays, hours, the works, and condition of service of the workmen of the contractor shall be such as may be specified in this behalf by the Chief Labor Commissioner Central. Now it is Deputy Labor Commissioner. Chief Labor Commissioner Central, while determining the wage rates, holidays, hours of work, and the other condition of service under Rule 25(2)(5)(b, the Chief Labor Commissioner is required to have regard to the wage rates, holidays, hours of work, and other condition of service obtaining in similar employment. Service obtaining in similar employment. There is no dispute between us that the Payment of Wages Act applies to much contract. This is not very relevant so far our case is concerned. Number rules, paragraph 6. Just now I have referred. Well, this is paragraph 6. Now let should come. Paragraph 61 আপনার এই Oh, page two. Page 33. That paragraph just I have read out. That's it. Now, look, come to paragraph 12. This decision of the apex court was subsequently relied on another judgment.
Huh?
This decision of the apex court that was reported in 85-1 SCC, first judgment, that has also been referred here. And so far 85 judgment is concerned, it was also referred in the subsequent case of the Supreme Court that is reported in.
So it has not been, so it is still,
Yes.
the valid judgment, I mean, not overruled or.
No, repeatedly it is referred. That is paragraph 5. Paragraph 12, it is stated, this said decision of the Honorable Apex Court has been quoted with the approval in subsequent pronouncement in Pinky Thermal Station versus such and such, AII 2009 2373. Now Miller, अभी क्या है? Manager है कुछ तो बोलना. Now Miller. भारत में कौन क्वेश्चन है? 4 ना? Now let's come to page 35 to 42. This case has some bearing. In fact, it will cover entire case, the judgment. There is a Bharat BSNL case, Madras High Court judgment. Page 35 to page 42. No, Miller. Now, first your lordship will come.
Para?
First is a contractor is para 4, subparagraph 3. Here the one point that was asked, that in that case the contractor was not made as a party.
This para 35 had already been taken up by you earlier. Page this
Para,
Madras judgment?
no,
No.
I prefer the
I thought the other one.
Bombay High Court judgment. Huh? Not question. Page 35. Page 35. I'm just referring now, Madras High Court judgment.
Yeah.
But here one point was cropped up that in this proceeding, contractor was not made as a party. This aspect was also here in the instant case before your lordship is also saying why the contractor is not made as a party, and this point was out. That your lordship will find para 4, subparagraph 3. Notice 7 again. The petitioner has entered into an agreement with the contractor who have been given license by the Ministry of Labor and Trade. They are necessary parties, and any additional liability can be fixed only after hearing the licenses, and therefore the impugn order is hid by non-joinder of the necessary parties, proper parties. Now its reply to this respect we find at para 18. This contention.
Para 18 of
1-8. Not well.
yes.
Page
41.
Page 41. 41. On analyzing the position of this case, though the principal law on this point is clear that non-joinder of parties is fatal in a given circumstances of this case, I am of the considered opinion that non-gender of the parties will not heed the decision rendered by the authority. Why not? That has been discussed, my lord. That your lordship will get para 8, 9, and 16. Paragraph 18. No. No, why not, my lord? Paragraph 8, 9, and 1.
You seem to be having a side conversation. They're
Yeah.
sharing your submissions. You all seem to be having a conversation on the side while making submissions.
No, sorry.
No, it's okay. Interesting. You make submissions, then you
No,
discuss something, then again you make submissions,
no,
again you discuss
my
something.
senior counsel asked me that what is the page number, etc.
Oh,
That is why I'm there. I to help him.
no problem, no problem. Just I found it interesting, that's all.
That's all. Now, para 8, that referred to. The rule 25 is quoted. That there is a rec.
Rule 25.
Rule 25 is quoted. In a case where the workman employed by the contractor perform same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wages, rates, holidays, hours of works, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. Now that is quoted at paragraph 8, provided that in case of any disagreement with respect to the type of work, the same shall be decided by the Deputy Chief Labor Commissioner Central.
Yes.
There is, here, in any other cases, wage rate, etc., this is very not important. Now, paragraph 9, 8, 9, page, paragraph 9, no? Paragraph 39.
Page 39.
Page 39. Paragraph 9. From the above proviso, it is clear that the Deputy Labor Commissioner Central is the competent authority to determine the wage rates, holidays, hours of work, and other conditions of services of the contract workers. Therefore, the contention of the learned counsel for the petitioner that the order passed by the first respondent without jurisdiction cannot be sustained. Paragraph 10. Before the first respondent, the writ petitioner did not dispute. No, this is very much important. Here it is covered. Lord. Before the first respondent, the writ petitioner did not dispute or deny the nature of work carried out by the contract workers, nor did they deny the fact that the contract workers are performing the jobs that are similar to those performed by the regular employees. I have just on the other, on
I
that,
don't think there is any doubt with regard to the fact that the Deputy Chief Labor Commissioner is the authority who is to decide the
no,
way.
there is no doubt.
There's no doubt. Then why are you going to that issue? Why we dwelling on that subject?
No, I am on paragraph 10.
Yeah.
Paragraph 10.
That is also not disputed.
Yes, that is disputed.
Huh?
That is disputed.
That's disputed. Which-
Paragraph
which-
10, what they wanted to say that the contractor was not made as a party. Contractor was not hard.
Yes.
Yes, in this case also, in this GSNL case also, contractor was not hard. Now,
Okay, but then this para 10 basically deals with the nature of work.
yes, nature of,
So nature of work is not disputed.
yes, that is what I am saying. Nature of work is not.
Nature of work is not disputed.
disputed. So
Maybe,
at the-
maybe nature of relationship is different, but
Ah.
nature of work is the same.
yes, that is most of that. No. 8, 9, 8. Paragraph. Madam Talaya. Now, your lordship, come. I think it's better, huh? No, 74, 1 is the same. There is first case of the Supreme Court that was reported in 74-1 SSC 596, where this validity of section 25, rule 25, along with the other rules were assailed. And the Apex Court has appreciated the provisions of the Act and made several observations at paragraph 14, 17, 20, 20, 30, and 31. Page 1 to 13.
Okay, so you're relying upon paras?
Para 14, 17, 20, 30, and 31. Actually,
14,
these paragraphs
14.
are not at all pertinent for our case, but to appreciate the provisions of the Contract Labor Regulation and Abolition Act.
Para 14, 17.
14, 17, 20, 30, and 31. Here, all those relevant provisions were discussed. Though it has no bearing so far our case is concerned. So, just to appreciate the scope of the Act itself, the Supreme Court discussed all these provisions because this Act was assailed before the Supreme Court, that this is not a valid statute.
No, so the provisions of the act are not under challenge.
Not on that.
Then
But so far, the section 30, section rule 25, the consequence of those things have been discussed.
okay, what does it say?
Let me skip it off or I can read it out.
It depends entirely upon you. You're the counsel.
That's it.
My pay scale will remain the same.
Page 5, paragraph 14.
Para 14.
The Act was passed to prevent the exploitation of the Act was passed to prevent the exploitation of the contract labor and to introduce better condition of work. The Act provides for regulation and abolition of contract labor. The underlying policy of the Act is to abolish the contract labor. Wherever possible and practicable, and where it cannot be abolished altogether, the policy of the Act is that the working condition of the contract labor should be regulated as to ensure the payment of wages and the provision of essential amenities. That is why the Act provides for a regulated condition of work and contemplates progressive abolition to the extent contemplated by Section 10 of the Act. Section 10 of the Act deals with the abolition, with the rest of the Act deals with the regulation. The dominant idea of Section 10 of this Act is to find out whether the contract labor is necessary for the industry, trade, business, manufacture, for the part or the occupation which is carried on in the establishment. Next paragraph. Next paragraph is paragraph 17. Page 6, paragraph 17. Next paragraph. Contractor under the Act is a relation A contractor under the Act in relation to the establishment is a person who undertakes or produce given a result for the establishment through contract labor. Here it is the case below. Contract labor. A contractor is a person who supplies contract labor for any work of the establishment. The entire context shows that the work for the establishment is the work site. The work site is an establishment and belongs to the principal employer, who has the right of supervision and control, who is the owner of the premises and the end product, and from whom the contract labor receives payment either directly or through the contractor. It is the place where the establishment intends to carry on business, trade, industry, manufacture, occupation after the construction is complete. Next, I go to 20. 20? The second contention of this paragraph 20, beloved, the second contention on this behalf, the petitioners, is that the provision of the Act and the
That
rules.
is not an issue here.
No, all right, let's keep it. Now, Millard. Bajjana to पुराने विषय में don't worry. Now, let's, here they have one thing, paragraph 15 से. Prabha Mosa. Prabha Mosa. Harvey. Paragraph 20. The paragraph 30 has some bearing there. It deals with the rule 25. The provision contained in Central Rules 25 5B are challenged as oh, sorry, let me take it. Not relevant. Now, Lordship, come to the factual evidence. That I have tried to copy the paper. Sorry. Without reading entire thing, that is a long judgment, Milan. Just give the photo. Paragraph. Comparison made. In the hospital, Milan, concerned workers, the listed one is Provo Deca. His year of engagement is page 60. It will, Lordship will get at page 67.
66 of what?
67 of the writ petition.
Which writ petition?
Item 18. What he has done, Millard, he has gone to every establishment and he called for the contract laborers as well as the regular employees. Their statement was recorded. And this recording was reflected in the judgment itself. So a long list is there. I'm just pointing out some pertinent points for the purpose of your Lordship's convenience.
Yes, sir.
Page 67. He's a medical attendant. Provo Deca. Yes, yeah, I had just give the space in this blood. His date of year of engagement is 2000. qualification is 9 pass.
This, I've got that, I've got that.
Huh?
I've got. This is what you're reading.
Uh-huh.
Yes.
Yes, yes, that is it.
I've read.
Similarly, nature of work is also there below. And it is compared with the regular employee. And it is, that is at page 67 itself below. Their nature of work is also same. Nature of work is same, duty hours is also same. Benefits are different here. Here, the contract workers are getting bonus and the regular employees are not getting better bonus. They are getting one PRP, personal related pay. That personal related pay, performance related pay. That performance related pay it depend upon the profit earned by the establishment. And that is not, but we are getting bonus, they are not getting bonus. They are getting house rent allowances. If no quarter is allotted, we are not getting all these things. Only basic wages and provident fund benefit. And basic wages was computed as the grade 1 employee of the regular establishment. Then your lordship will find security guard in hospital. That is at page 3.
No, now what is the difference in the pay that they are getting and in the pay that they are getting? So according to you, the difference is they are getting performance related pay and you're getting a bonus.
That is not very relevant so far this case is concerned.
Then
But
why
as
you-
they have, it is mentioned here, and that is why I have pointed out. Well, only thing is that basic we are getting some amount, 16,000 or 17,000 or 26,000. And they are getting 1 lakh above or 80,000 above. That is one thing, blood. The performance is different. Performance is identical, either identical or similar. Nature of duties. Nature of duties is identical
How
or
much are you getting now?
blood
How much are you getting now?
from the
How much, huh?
from the judgment itself. Blood.
How much is your client getting?
Oh, now. Now in the year 2017, 26,000 something. Probably now it will be about 40,000 or something. It will be.
How would you get that 26,000? What is the basis for getting that 26,000?
Basic of the 23,000 was settlement. First settlement that was made, whereby the basic of grade 1 labor of the regular
Show me from the records. Don't tell me like that. I don't know.
page 58. Okay. Settlement to what? So you should come, we will come. Page 58. It is their document. Blood.
Doesn't matter.
Page 58.
Yes.
It is their document. Pay scale of tradesman, attendant, grade 1, and other allowances. 27,629.
So why are the petitioners agreed with this?
That's it. So far, the regular employees are concerned, they are getting much more than us.
Is this what you're getting this 27,600 29, correct?
Hmm.
Is it?
Hold on. 59. 59. Fifty-nine, you know? So there is, our is page 59. Wages being listed WCS again. Wages being paid to listed WCL 1, 2, 3, and other allowances was on date. Page 59.
Yes, now, my question is, this wages are fixed by that commissioner, correct?
No,
Deputy Chief Commissioner or whatever, whoever. He has
This
fixed
wages?
this, yes.
no.
Acha,
This was just fixed by the Oil India Limited.
these are being paid to whom? Page 59 is being paid to whom? This chart, this amount,
Paid to us.
paid to you, correct?
Paid
On what basis?
on the basis
Who has made this chart payable to you?
they made.
Why should they make?
They give it to them. I can refer.
And what is and then if they have made this, why should they be agreed with this?
That is, that is their problem, Lord. But just this is the
According to the council for the respondents, this page 59 wages has been made by you.
Your
Is
Lordship,
that correct?
yes,
This page 59.
yes, that was supplied by them. That is also consistent.
No, let us be clear of facts.
Sorry.
Page 59. The chart on top for list 1, listed 2, listed 3. Wages being paid to listed 1.
Page 58 is below regular. And page 59 is for contract labor.
So page 59 is the contractors, and this has been made by whom?
We are, we are by this chart indicating the salaries which are paid, wages which are paid to regular as well as the contract labor.
No, I agree. Now this page 59, this chart.
This is, I think, relatable to 2017.
No, whatever. I'm not saying that.
No,
Is this chart at page 59?
yes,
The wages made by you or by that commissioner?
no, this is by us.
This is by you.
Because
So you- so
actual
you-
payment
so-
of the wages as far as the regular.
So
and contract are
they are getting this.
Yes,
They're getting this.
yes, from us.
Yes,
without
but now
anything.
that commissioner has made some another chart.
Yes.
Correct.
He has not only given that, but he has added,
That 5,000, 3,000, all that.
75.
Ah. So where is that? That is what I'm asking you. What are the wages that you're getting?
This is at
This is
the
that.
page.
This is the wages that you're
Yes,
getting.
and
Acha, that has not been implemented.
That has not been, it is state. by
They
the
have
court.
stayed by this. Oh.
no, this is a much earlier thing. It is 2017. The latest position is at page given. I have placed those.
Anyway,
documents.
let's,
Because I
let us
again
go
place
back
it
to
to
that
refresh.
position.
That has been now, after the new latest settlement, the wages have gone up.
So
roughly speaking, I'll just give your lordship.
No, so won't there be a corresponding
Yes,
increase?
that is what I'm trying to say. After the latest settlements, the contract laborers are now getting about 39,000. Those who have not signed the settlement, your lordship recall that that some people have come that they want to sign the settlement and get the benefit of the latest settlement. If they sign, and then they get 46,000.
Is one conditional one.
The contract labor. Page 131 and 132.
Anyway, how much time do you need to complete your arguments? You finished?
What would you say?
Oh, watch it. No. Now, so far the evidence is concerned, Judge, I have just brief notes of these evidences.
No, this is all right. I don't think this is the issue.
Yes, this is the issue. Judge.
No, this is the issue.
Yes.
What they are working and what not. No, the issue is that they are working as contract laborers. That is not disputed.
Yes, no.
So there is no dispute that they are working at the establishment of the oil. There is no dispute that they should be given wages similar to the permanent employees.
Permanently. But that has not been given.
No.
And-
So the issue is now that wages that are payable has been made by the deputy chief commissioner or whatever.
Yes, yes,
Correct? Now they are saying that it is wrong.
wrong.
They are harping on that 5,000 or 3,000 rupees increase, I think. Correct?
Yes.
Now, so what is wrong with their submission? What is wrong with their understanding of not their understanding, what is why?
Their contention.
Yes,
Their contention is
what is
that
wrong with their contention?
their contention is that we are not entitled to this because we are bound by the settlement.
That is one.
That is one. Second contention is that we cannot be equated with the regular employees because they are regularly recruited
Okay,
person.
that
Yes,
is
correct.
that is different.
That's different.
You are supposed to get the minimum of the pay scale, correct?
Hmm.
Is it? No, you're supposed to get the equivalent.
Yeah, similar, not equivalent.
Similar.
Similar.
It's similar.
No,
What
I
is-
am not. I am not claiming or the contrary. This deputy labor commissioner has not given the exact wages that is being paid to the regular employee. He
I
simply
think
annexed.
I think you should tell me what has simply annexed what? The
Yeah.
deputy labor commissioner has
Only enhance some wages, not at par with them.
but you're not aggrieved with it. You're not aggrieved with it.
No, I am not agreed. I am supporting this.
Ah,
They are agreed by this.
yes, they're aggrieved.
They are agreed.
Now
by
they're aggrieved with that 5,000 and that addition of 5,000 and that 3,000.
Ah.
Now, what is it correct the way he has done it? That 5,000 and 3,000?
No, he tried to mitigate to some extent because there is the gulf of defiance. There is a gulf of defiance that he tried to mitigate to some extent by giving 5,000, 3,000 and 2,000. What is the harm of it? Because he is an expert person. He understands the law better. He understands the wage structure better. He has not made any attempt to give the salary or wages at par with them. Only he tried to give and then some. This is singular and nothing else. And he has specifically stated at the last paragraph that so far the other benefits are concerned, that will be regulated by the existing rules governing the field. Only thing is that basic wages was extended. That by 5,000, by 3,000, and 2,000, and some other consequent. That your lordship will.
Now, you see, one thing is the labor commissioner has fixed the wages on the basis of the wages being given to the grade 1 employees. Correct?
No, labor commissioner has not made any distinction to the grade 1, grade 2, grade 3, etc. His only idea, his only thing has to be considered whether the person concerned is performing similar nature of job or not. That is, I am repeatedly harping by referring several judgments.
But supposing there is a workman, say workman, there's a welder workman.
He is getting, supposing he is a qualified person.
So that that welder, how many grades of welder will there be? There'll be 1 to 9, 1 to 8, how much? 1 to 9, 10, how much?
1 to 8, 1 to 9, whatever.
1 to 9.
Hmm.
So the highest grade will be what? Grade 1 or the lowest grade will be grade 1?
5 to 9. Say,
Huh?
for example, highest grade is grade 6,
Ah,
hypothetically.
ah.
Example. Now, question is that he is grade 6, he is doing the welding job. All right. Now, a contract labor is also doing the welding job.
No, I'm not on that. I will come to that later. As, my question is, there can be different grades of a welder,
Yes,
correct?
Hmm.
So his job will remain the same,
same.
but because of his length of service, probably
Yes.
his grade will go higher and higher. So now the labor commissioner has made the payable to the contract laborers on the basis of which grade of employees of the Oil India.
Defined grades,
Huh?
defined grades who are performing similar nature of job.
Define the,
Grades who are performing similar nature of job. Labor
So-
commissioner basis is of who has that he is performing similar nature of
show
job.
me that, I don't know, where is that? Now you see, no, they are working similar, there is no doubt about it.
Yeah.
But then, did the labor commissioner make the pay payable to the contract laborers on the basis of a grade 1 or a grade 2 or a grade 3 or a
No,
grade
labor
4
commissioner
worker?
has not interfered anything. Labor commissioner simply stated the existing wages that are being paid to the contract laborer should be enhanced to by 5,000, by 3,000 or by. Till then, my lord, if we give this.
I don't, is it, I don't know.
Yes, the lordship come to page 80. Petition to the-
If that be the case,
Yes.
if that is the case, then what is the problem? Give them
Yes,
5,000, 3,000 or whatever increase is required. Petitioners, yes, Mr. Goswami, you.
Let him complete. because-
Huh?
Let him complete. I'll address your lordship on his submissions because this is not a question of Milord, the way he is putting. Milord, the statute provides an authority with a purpose. What is the purpose? That if the workers, contract laborers are doing the same and similar work, then they are entitled to the same wages given to the regular employee.
Correct.
That is the scope of his jurisdiction, Miller. Now, how do you come to that finding that X in so-and-so grade and Y in so-and-so grade are doing the same or similar? There has to be some evidence. Somebody has to explain why they are having this classification of regular employee and casual employee. Who will explain that?
No, that I don't know. Why?
Nobody, but except the employer. Contractor also, but let me say that the employer alone can say the policy behind having a set of workers who are regular and a set of workers who are
Contractual.
contractors. If you don't take evidence, how do you determine that question? That's the crux of the matter. You are given that power. It is a very important power affecting lot of employers. Now, there is no indication there except the grant of the power in Rule 25. Now, he has to collect evidence to come to a finding that X and Y are doing the same work. He can't have that without hearing the two sides. One,
Has he made a finding to the effect that they are doing similar work? He has made a finding.
Milord, I
Here-
have placed his Milord findings. I will again place it. But the Unless, Milord, the whole difficulty of this process which he has adopted is that you are not taking evidence from the person who is the best man to give you the evidence, whether it is same or similar. Who can say that, Milord? Not the contract labor can say that I am doing this. The
Mr.
regular
Das,
employee can say, I am doing this. But why is the employer having two sets?
are you going to be ready for this matter?
Not yet. His case is except on one point, which is a little different. So far, what I was suggesting to my lord, that fix 2 dates, one for you both, one for me, and finish the matter, because again, it is getting all
Confused.
confused.
I'll take hardly one.
No, no, one
But take
thing,
1 hour of the day, there is no problem, and he will also
okay, you
complete.
take 1 hour, that's good.
Ah.
But does it have to be decided together, this matter?
These two are similar to some extent, except in his case, there is a additional point. Because a reference was earlier made, a labor court was, has taken.
Decided.
A national tribunal, no? Central tribunal, and they asked for regularization. That was, Milord, rejected after taking evidence of both sides. So that will be a point whether how relevant it is and what not. But that is in his case, which is not there in the first case, which your lordship is here.
So will this decision here have any bearing on your case?
Yes, Milord, because rest of the pleadings or the rest of the issue will be same, except that in his case, the union which is taking up the case first went to the central government to get a reference, which they gave, and the labor court or industrial tribunal, CJ, Central Industrial Tribunal, took evidence of both sides and then gave an award.
Gave an award in his favor.
No, against him. So
Against-
what is the
Acha,
effect?
so he's filed an appeal.
No. He has now gone to the Contract Labor Regulation Abolition Act under Rule 25. So this is the issue so far he is concerned, additional. Namely, what is the effect of that award which was given at his initiative by the Central Industrial Tribunal. That will be the issue so far he is concerned. That is an issue for his case only, not in this case.
So that is the issue of law, basically.
Law.
So there's nothing to do with this.
No.
This is basically the wages. So
Wages.
that's a different issue altogether.
And Milord, here, as I see it, Milord, the basic question will be, how do you proceed? In my opening also, I submitted before your lordship. How would you have to give some guidance to the Chief Labor Commissioner as to how he will proceed. It's a quasi-judicial function, Milord. Fixation of wages is one of the most delicate issues as far as industrial relations are concerned. So can you conceive of a determination without taking evidence? Bare minimum evidence that is known to law. Namely, that this is my case, here is my evidence. Then the opportunity is given to the other side. You give your version, cross-examine if you want. That's all. That's the normal which your lordships have laid down.
Okay, so so if we decide that issue,
That is,
supposing we decide that issue against you, then what the labor commissioner has done is correct?
no, Milord.
No, then that is again you have challenged that also.
Yes, yes.
So you have challenged it in every step of the way. So basically, as
Milord,
to
this is-
so
both
you
are
are
related. Your lordship will kindly see. How can you come to a conclusion
Huh.
without giving and taking the version of the employer? Can you conceive that in a fixation of wages, Milord, that the employer is not even heard? Because this will be absolutely bizarre procedure.
Okay, so your challenge is twofold. First of all, the wages that has been fixed by the labor commissioner has been made without hearing you. And
The procedure adopted by.
anyway, the procedure, whatever procedure, without hearing you basically,
Yes, my lord.
basically without hearing you. And secondly, the manner in which he has done it is
We are unknown
it's,
to law. You can't
but
say
what you-
at 10,000
does it
and pay.
unknown to law. But then how do you make it then? You'll have to show as to how it should be done.
Yes, my lord.
How?
You are coming with a claim that what is the scope of that rule 25? When will it come into force, my lord? It will come into effect only when the worker contract labor claims that, look, this is what I am doing. This is the same job as X, who is a regular employee. And therefore, I am entitled to the same wages. That's the effect of Rule 25. Now, you have taken the statements. Have you put them before the other side for cross-examination? No. Some amount of procedure is inbuilt in the power which is given. Because it relates.
May not be in the form of evidence as such.
Inquire, you have to inquire. That's what the case cited by him also says. Because, my lord, kindly see, wage fixation, even several cases are there where it is said that it is not for courts even to determine, because it is better to give it to a technical.
But where does it say that evidence has to be taken in the, where does it say that?
It is not there in the, under Rule 25, the procedure is not prescribed.
Then,
But your lordships are aware of all those judgments of the Supreme Court.
no, I'm,
No, I'll cite them if necessary.
you'll have to show me.
Yes, I'll cite them. If a power is given to determine whether the wages are same or not, obviously, it will require some evidence.
It will require evidence, but maybe not in the form of cross-examination or anything like that, I
That
doubt.
is the person, who are the persons concerned? One is the employer, the second is the contractor who.
They maybe, okay, to the extent that the view should be taken, maybe. I don't think that you can go so far as to import.
I am not going at all
proceeding.
any far, my lord.
Hmm.
I am only suggesting, my lord, that in the context of Rule 25, it confers a very extensive power to the Chief Labor Commissioner, Deputy Chief Labor Commissioner. Now, he is a statutory authority. For what? For determining the question whether the wages, whether the duties are same and similar. If he comes to a conclusion that they are same and similar, the consequence is the same wages will go.
So is it your case that you were not heard?
You know, kindly see the procedure he has adopted. He comes to Duliajan, stays there for 2 or 3 days, goes to 8 establishments out of 36 departments, and then he calls some people from the permanent workers, regular workers, and some from the other workers, and take their statements.
Management is not taken into, management is not called.
No, look, who can determine why they are having this dichotomy? There has to be some reason, look. And as I show below, I have already placed if you go by the total wages, which is ultimately what you go at the end of the month, the page 58 and 59 is of a earlier period of 2017, the latest, which was in 22 July 22. Huh? Where the prices have again, wages have again gone up for the casual laborers, contract laborers. And a contract laborer is getting, if he has signed that settlement, he is getting 46,000. You- your
Grade,
lordship will not find-
which grade?
Below, these people have no grades.
I know, no, I'm
It's a-
saying that 46,000
Yeah,
will be equivalent to the salary of a permanent worker of what grade?
of what grade that basic will be 2010 settlement ensured that they will get the minimum of the basic. Grade one,
Grade 1 is the highest or the lowest?
lowest. They will get the minimum of the lowest grade, which is what ultimately, Millard, after all the judgments, 2017, that Supreme Court case, Justice Keher's judgment, he also said what? And what all the high courts are now saying, so far as the casual or contract laborers are concerned, minimum of the scale. That was given by the company voluntarily in 2010 settlement. Not now. So they have got that. So the benefits I'll.
How much does so a permanent grade 1 worker will get above 46?
Now, I think that also I think we have given. Huh? In some cases, Willard, it will appear when you, suppose you recruit now, the contract labor will get more than the regular in the same grade. So that is the effect of this order. That is something which has not happened, Willard. We have given the chart also, that page.
I don't remember.
No,
Off and on,
no,
you'll
no,
give me.
of course, we don't remember ourselves, how your lordship remember with all the cases that have come. Milord, this is something very unusual, this fixation. So far as grade 3 is concerned, the lowest grade, he takes it, they are getting, suppose earlier 16,000. And the minimum of a regular is say 27,000. I am not giving the full details. But he adds, Milord, to that lowest casual worker, contract labor, which is called WCL3. He adds what he is getting to make it equivalent to what the regular is getting after all these years, 27,629. He adds 16,000, 10,000 added, so it is so. That is not what the rule says. It is not making it equivalent. What he has to first come to a conclusion is that the functions are same and similar. On that basis, if that conclusion is arrived, the consequence is inbuilt. Rule says that.
And
that you will get
the consequences are that equivalent.
equivalent. You don't have to make it equivalent.
So equivalent means same.
Same. If the work is same and similar, they will get the same wages. So the effect of same and similar, his finding will mean that they will get the same pay with all the benefits. So there is no dispute on that score. But the first part is the most relevant. How do you determine that it is same and similar? If you don't take the version from the employer, why he is having this dichotomy? There must be some reason. You may be having the same designation, but your grades are different. Why? Your lordships have laid down the different parameters for that. Qualifications, the procedure of recruitment, everything has to be taken into account. After that, only your lordship the court will see whether it is same or similar. So the same principle will apply so far as the statutory authority is concerned. He is fixing wages, basically. Therefore, if you go to a tribunal with this, what will be the procedure? Normally, we don't forget the contract labor. Wage fixation, both the union will reduce evidence, the employer will reduce evidence, and then
That is a tribunal.
tribunal, this power is of that nature, it's a quasi-judicial function. You are fixing a wage for a large number of people. It has severe effect, my lord. In fact, my lord, he is finding at page 75, which I placed, my lord. He himself admits that it is not identical. His own finding, my lord, negatives application of Rule 25 in this case. Page 75, my lord. At page 75, my lord, his own finding is that they are not identical. If it is not identical, Supreme Court says if you want to have the parity principle in operation, it has to be identical. And he himself says at page 70, after perusal of the above statements of contract workers and permanent employees, it is a fact that there is no total similarity. If this is his finding, my lord, on the main part of the Rule 25, then where is the question of all this, my lord, adding?
So I think what we can do
Yes.
is this matter we can continue at 2 o'clock.
Yes.
Your matter we'll do it some other day.
May I suggest one thing, my lord, subject to your lordship?
The 2020 award. In 2020, they have been different.
What is
In the meantime, they have brought in some different settlements. And they have settled the matter with some of our members of the union, and they have given the rate. They have enhanced their rate. But the benefit of the award has not been given.
No, whoever has signed, they have got the
They are
benefit.
employer, they are rich employer.
No,
These are sanitary workers. They are not getting the benefit of the award.
So what are you trying to say?
So I'm trying to say, madam, this matter should be hard into, matter conclusively, they think by your lordship.
That is exactly what I was telling my lord, that fix one day for them and one day for
No,
us,
that is not a, you see,
and then finish it off.
you see the problem, I'm saying, what is the problem? Is there any problem if the matter is segregated? One matter heard first, disposed of, then the second matter heard and disposed of. That way.
May I say this?
No, it was before me, it was before my time.
No, it was earlier also.
Okay.
My lord, your lordship is right, my lord. Both can be heard together, there is no problem.
But the writing of the judgment is going to be two, result
No,
one.
This issue is common to both.
Maybe.
He has an additional point that we will deal with.
Okay, so you have
there-
also
there is
got,
no-
it's,
there will
the
be-
facts are similar.
That is, otherwise the issue is same.
Issue is that
Uh,
I do not.
Therefore, I am suggesting to your lordship that have 2 days only for this.
Is it Oil India? You also know.
Huh?
Yes.
Yes,
Oil
yes,
India.
All India.
So is it your case? You see, in this case, the stand of the writ petitioner is that the Oil India people, the Oil India management were not heard by the concerned labor commissioner at the time of fixing the wages for the contract employees. Is it the same in your case?
Yes, procedure is same, my lord.
Huh? Or heard?
No,
In
no,
the, out here
procedure-
there's a difference.
No, procedure is same, my lord. Nobody was hurt. The same procedure was taken. so far.
Anyway, that is a different thing.
Huh.
Because one aspect I want to know, if the management was not heard, supposing it was not heard, actually not heard, would it have been fair? According to you? No, that forget that. Supposing in the award it had said, yes, management was not heard. Supposing it had said that, then look, I'm not on that. I'm not on that. Please, let us not go deep. Just one answer at a time. Whether if the management was not heard, supposing that was a fact, would the wages fixed by the labor commissioner be fair?
What content? What content? What? Similar nature of what?
Similar nature of work is that.
No. So that is what. Now to find out whether there was a similar nature of work being done by the contract laborer, would it be required to hear the principal employer? No, that is the question that is being raised by him. The question is this, the question that he's raised, just a minute. That no, I'm not on that. He's hurt, so it's okay. But the question is this, hypothetically,
Yes.
hypothetical question is, the question is basically is to find out whether the contract workers had done similar nature of work. Was it a requirement of the labor commissioner to have also heard the principal employer?
Yes. They were afforded the opportunity to submit their representation. And in that representation, they have not denied that these persons are not working the similar nature of job.
No, that is incorrect.
Let me-
Contrary to record.
That apart, my lord, all the contract laborers were called upon and their statement was recorded.
No, that I'm not on that contract labor.
No,
I'm not on that. I
I'm-
know that part to leave it. I'm only on that the first part. Whether the management had been asked to give
Yes,
their side of the story with regard to the issue of whether there was similar nature of work being done by the contract employee.
None. Never-
yes.
I don't know.
Clear.
So
Page
we'll
54,
clarify that.
Huh.
We'll clarify that. If once that is clarified,
then all that.
supposing we find, supposing you and I, we both find that they were not given opportunity of being heard, then what would your submission be with regard to the labor commissioner coming to a finding that the similar nature of work was being done? Then it would not have been proper. Agreed. Not have been proper.
Yes, to some extent, your worship is correct.
That's what I wanted to know.
Yes, I.
No, it's like this. Supposing I was hiring, supposing I have got contract laborers, I have got one or two permanent labor. I am the owner of the
Authority.
business. So I'm the business owner. And the labor commissioner comes to a finding that this worker, contract laborer, is doing the similar kind of work
Yes.
as this person,
Yes.
permanent work. But he has come to that finding without hearing me.
Yes,
Will that be proper?
no,
That's what I'm asking.
that's all. I will
So-
check.
So let us see that after at
After
2 o'clock. Then we can go on to the next issue. That's all.
Yes.
Your case is of course different again.
No,
Same
same.
thing.
That
No, but then
That is an
it's
additional
again a
point.
question of facts.
that is an additional point. May I suggest, my lord, that your lordship give us 2 days. We can finish it one day, but allot 2 days as your lordship pleases.
But that will be later,
And
after
then
tomorrow.
we'll finish it once for all.
We are here today, again, day after tomorrow, no chance. I've got cases fixed, you know.
No, that's why
Actually,
I'm
this
saying
is the,
it
this
may
is
not be
the,
No, I
open.
have no
this is
objection
the only case that I have
today.
which has been, no,
No.
which has been, you know, in the
Going on.
lingering type of
Yes,
case.
yes, yes, that will be-
I usually don't keep cases
It
lingering.
can be completed by today itself.
Going on, but your lordships will
It
not
can be
be able
completed by
to
today itself.
complete it.
So far, my case.
Maybe not be able to
That is
complete,
why
but
I
at
am
least I'll have some idea.
That
Let
is
me have
why-
some idea. little bit.
That is why I am suggesting, Milord, let it, your lordships, according to your lordship convenience, fix 2 dates. Your
Very
lordship may not require the second day, but give us that privilege to have 2 days. They will finish their side, I will finish, I can promise.
Huh?
That will be the best way to go about. Otherwise, Milord, it is not going to end.
Let me have an idea on that point, at least.
Yeah.
At least, we'll sit for at least 10-15 minutes, just find out. I want to know, I want to hear his side of the story
Yes, yes.
with regard to that issue of whether you were given an opportunity of being heard and whether you had taken that opportunity.
No.
Yes,
Because according to him, you were given the opportunity, but you
Yes.
did not take it.
Yes,
No, no.
yes.
This is not correct.
So let us
Yes.
see, let us see.
Let them say that.
But out here, there's no award.
The order.
Yeah. Right. I will see.
So, Milord,
Maybe
your lordship will fix it 2 dates and do it instead of today, tomorrow.
why?
Today.
Why?
No, it will be better, because we have to reply also.
I have got some other court cases.
That is also one of the reasons that NRC matter is also going on. So your lordship, subject to your lordship convenience, if your lordship gives it on a particular day, allot it. for us.
He's going to go. He has got some other.
No, not some other,
instructions.
that NRC is also a very delicate issue here.
Where? In whose court?
In, I think, 14, this is psychiatrist. And also partly very important for the state.
Everything is important.
No,
What
no,
to
that
do?
is true, but that the extent of that importance for the state will not is important. And Northeast also. That is why I'm saying.
I don't know. It depends upon you.
Yes, kindly fix a date only
What
for
if it
these
does?
2 cases, we'll finish.
Client, they are suffering 2009.
No, we are in the midst now.
Stay order operating.
Of course.
Big employer, it's.
Even a big employer, your lordship know the position of oil manufacturing or production in India. We are dependent for our requirement from on imports from others.
Otherwise, actually, the issue is that only.
That's why I'm saying the crux of the matter will ultimately end there. Your lordship need not go into all these facts. It will be that he has the procedure he has followed is not in tune with what is required to be done following natural justice principles. That's the crux of the matter at the end of the day.
So the case is this. He's saying that evidence should be taken. I don't
5
think.
days gone, man.
Huh?
4, 5 days gone. 4 or 5 days are already gone.
No.
That's fast.
No,
So
you
I'm just
did.
telling you to
Your
be,
time has not
I'm
come
just
yet.
telling you to be ready.
My case has not been reopened and they have checked the case with this case.
No, that's why we are, we have to, I have not argued your case. Why are you bothering?
But there is stay order operating.
No, it will come.
2019 Bangladesh award.
That is.
We'll detach this matter, I think.
Lordship will hear the matter together because the matter.
Today, maybe a little.
He's asking for time, I don't know.
Why they are only clearing. Matter should be hard.
In fact, Mr. Goswami has been asking for time as soon as he stood up.
Only because of that, because I am also mindful of that engagement. So subject to your lordship convenience,
My convenience will be only end of April.
That is also, I have no problem. We'll do it. Whenever your
Otherwise,
lordship-
what we can do is we can release this from.
No, 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 please don't do that because
And
scholarship.
and we can detach the cases
No,
and you all hear them.
no, no, one day your lordship leaves, it will be absolutely clearly over. Give us a day, that will be absolutely okay. Whatever suits you.
Okay, I don't know, leave it up to you. Look, for me also, I don't want, this one I don't like about part heard matter. You keep it part heard and then it doesn't finish.
No,
in
no,
the
this
court.
is going on for some time, don't release it now. One day, we'll finish everything. Kindly do that. It will come down. to a
Yes,
short
when
point.
do you want?
What day,
He
whatever
doesn't
day,
know,
I have no-
he says that he's got some NRC matter,
No.
which is more
Might
important
come, Milord, that is the
right
problem.
now.
Please, I will not take more than 10 to 15 minutes.
Yes, very good.
Okay, what we can do, Mr. Goswami,
Yes,
you need not be here in the afternoon.
Huh.
Your junior can be here.
Huh.
I will not decide the matter. I
Yes.
will ask him a few questions.
I can't say anything to that, Milord, but
I will not,
Milord, I will be personally would like to be here, Milord. That's the only reason. Your lordship can have it this month also. I have no problem.
no, this month, what do you think? I've got other matters
Yes,
all fixed.
whatever suits you.
I've got matters all fixed. we
Because
have,
I raised this
we have
question,
always-
it
we
was
have
not
fixed-
argued,
we have
Milord, because
fixed
he has not
certain
replied to
matters.
that.
On third also, we have fixed that.
Hmm.
The bunch of around 50 matters we have fixed.
Your lordship can fix any day, your lordship. can. This is now March, April, whatever. Huh?
April, second week, so it's going to be motion week again. I have lengthy matter that time.
Something like that.
And week just after Bihu, probably I won't be here, 1 week. So.
We have,
We
2 more
can try
weeks.
end of May, end of April. 29.
Yes.
We can try that. Have we fixed anything? No.
Yes, that will be good, because
Right.
Thursday,
On the prayer for adjournment made by Mr. P.K. Goswami, Leonard Senior Counsel. For the petitioner, I'll list the matter on 29.
29. That will be all. Tuesday,
29 or first?
whatever.
First might be better, I think.
I will look. I have no problem.
My lord. In this matter, my lord, my order is at 22/2023, my lord. Honorable Court directed the respondents to produce some record, my lord. And they are taking repeatedly time for producing that record, my lord, as per the previous orders, my lord.
So,
So, my lord, the records are required because
Okay.
earlier
who is
also,
appearing for the other side? No one is there.
Mr. K. Gogoi, he was representing earlier.
Right. The petitioner's counsel is present. No one appears for the respondents. Accordingly, let this matter after the vacations. The respondent shall produce the official record
Yes, ma'am.
on the next date.
Make decision. But the matter relates that what chips, wrong rosters were followed,
Wrong.
wrong rosters were followed. Earlier round of litigation, we approached this court. Those advertisements where wrong rosters were followed were set aside. Pursuant to that, again, we had to approach the court. Now, de-reservation is the issue.
What?
De-reservation, Lordship. In terms of Article 16(4)(b), de-reservation cannot be done. Posts which belong to the reserve category candidates, Lordship, there has to be a categorical finding that these are the backlogs. Then these are the existing vacancies, on the basis of which, along with the backlog vacancies, the present vacancies has to be filled. Now, Your Lordship, this is in violation of three judgments of the Supreme Court. R.K. Sabharwal is very clear. Post has to be earmarked. Each post gets replaced by this is known as the replacement theory. Where a post is earmarked for the reserve, it cannot go to the unreserved candidates. Candidates who are reserved can compete as unreserved if they are meritorious. Then, Lordship, the second judgment, General Singh says, now the concept of cadre-wise promotion, that has to be followed. It has to be cadre-wise, not post-wise. Second thing, thirdly, Lordship, this backlog vacancies as and when arises,
Yes?
backlog vacancies, Lordship, as and when it arises, first the backlog vacancies has to be filled up. Then, Lordship, they will have to come for the present vacancies. Now, Lordship will have this first order, which was passed in the earlier round
No,
of litigation.
what is this? This is a contempt, no, this is a writ petition.
Lordship, there is a writ petition. Pursuant to the filing of this writ petition, there was an interim order that they should not publish any advertisements. They went for an advertisement because the judgment of the Supreme Court,
Order.
R.K. Sabharwal, Lordship, that is that. Now, Lordship, it was a guideline by the UGC that when a roster has to be followed. It
No,
has
no,
to
what
be
are you
published.
challenging here?
Lordship, here is the advertisement. Post was earmarked for an SC candidate that was de-reserved. Some unreserved candidate has been selected on that post. That is
Okay.
Lordship. So, Lordship, if I may take your Lordships to the earlier round of litigation judgment, order passed by the Honorable Court. It's 230.
Page
230, Lordship.
200,
30, 30,
30.
30.
Yes.
So the relevant portion starts at page 232. Order dated 14/6/2023, Lordship.
Yes.
If I may read, Lordship. Heard Shri B. This and this learned counsel for the petitioners. Also heard Shri SCKL learned counsel for the Assam
Okay.
University.
The next.
Next, the grievance of the petitioner, out of which this petitioner number was in his association, is with regard to a recruitment process initiated with advertisement dated this and this 6/8/19, 7/9/19, 8/8/19 concerning 6 numbers of posts. The principal ground of challenge is that the post earmarked for reserve category have been de-reserved without following the due process of law. See, this and this learned counsel, however, fairly submits that he has been instructed by his client that in the meantime, the policy of de-reservation has been withdrawn and accordingly placed for a direction for initiating a fresh recruitment by setting aside the earlier recruitment process initiated by the advertisement. The aforesaid submission of this, the learned counsel for the petitioner is endorsed by Shri KR, the learned counsel for the Assam, but submits that the decision for de-reserving has been revoked. See, this and this submits that it is up to the authorities to take a decision. Now, Lordship, this is important. MSS gave the learned counsel for the respondent number for, however, while referring to the affidavit in opposition filed on 16/12/22 had submitted that the decision has been revoked as steps has been taken to prepare the roster by following the reservation policy. Lordship, this was the undertaking that they have given, it will be followed, reservation will be followed. Now, Lordship, at the last paragraph, in view of the above, there is hardly anything left to be adjudicated in the writ petition. Accordingly, the same states allowed by setting aside the impugned advertisement dated 6/8/19, 7/9/19, and 8/8/19. And in view of the admitted position that rosters has been prepared afresh, fresh recruitment may be initiated. Lordship, that from the bare perusal of this order itself, Lordship, it transpires that a fresh roster ought to have been prepared. Now, Lordship, what has been done? Your Lordship will see the meeting minutes where a resolution has been taken.
Fresh
These
roster meaning as per the reservation policy only,
policy
nothing
only.
new.
And Lordship, the earlier advertisement would set aside.
Correct.
Those orders say so. Now your Lordship will have page 222. This is a resolution of the respondent authority.
222, it goes
220.
backwards.
Lordship.
22 years.
Yes, sir. Lordship, this is regular item number, agenda number 13. Item number 13. A writ petition, white case number WBC this and this was filed before the Honorable High Court by the
Where is
Assam.
that?
Lordship, page 222.
Yes.
Lordship.
Hurry petition, yes.
Petition white case number this and this was filed before the Honorable Guwahati High Court by the Assam University SC Employees Welfare Association and others versus Union of India and others. The grievance of the petitioner were about a recruitment process initiated white advertisement dated 6/8/19, 7/9/19, 8/8/19 concerning 6 posts of the post. Your Lordship, this is important. The principal ground of challenge was that the post earmarked for reserve category has been de-reserved without following the due process of law. It is important to mention herein that the university had not proceeded with the recruitment of the above mentioned 6 posts meant for the academic departments of hospitality and tourism department, computer science, philosophy, biotechnology. Lordship, I am an aspirant of the biotechnology. I have a PhD. History and electronic and communication is due to the interim order of the court. The university through Sri S.C. Standing submitted before the court that the roster has been prepared and would be acted upon. The copies of the roster register were made available in the public domain and necessary documents were also provided to the AUSCWA. Honorable Mr. Justice S.K. Midi, after hearing the learned counsel of the parties and the standing council of the university passed in order 46 that there is hardly remained anything left to be adjudicated in the writ petition since the roster point has been prepared. Fresh recruitment may be initiated by the following the due process of law in pursuance of the order of the Honorable Guwahati High Court dated 14/6. The polling positions are to be advertised at the earliest since the university has already begun the process of recruitment. In the light of the directives of the Ministry of Education, Government of India under the mission mode, recruitment for all the vacant posts, including the 6th position of the department. Lordship, this 6 position are the same which were in the 6th statement. No,
This is position, this, what, this 6
the 6
Position.
positions of the department are cited below. Lordship,
are,
Lordship, the 6 vacant posts, which were earlier in the 6/8/19 and the advertisements, which were published. Lordship, fresh roster ought to have been prepared. De-reservation should have been taken into account. Lordship, these were the same posts.
no,
which were
but this reservation is there, ST, SC. I mean, it has been restored, reservation has been restored.
Lordship, no, Lordship. Here the point was that there was a post of OBC. I will just demonstrate.
There was a OBC post.
OBC post, it was turned to unreserved. I'll just demonstrate. I'll just take-
For which
For the assistant
department?
professor, Lordship, at point number 5,
For which department?
for biotechnology. Lordship.
Biotechnology,
Biotech-
okay.
Lordship,
So
I'm
there was
referring
an
to point
OBC
number-
post,
That was an unreserved post. That was post for the SC.
OBC,
Yes.
OBC or SC?
Lordship, that is the confusion. I'll just clarify here, Lordship, because it was earlier at point of time, 8 points ought to have been marked for the SC. That was a backlog vacancy. Here, Lordship, what they do in the year 2019, they reserve for SC, give it to a unreserved person, then again they change in terms of this notification, put it to SC, and they again give it to the unreserved. I'll just demonstrate, Lordship. It is.
They again give it to unreserved
They give it to unreserved.
after the judgment.
After the judgment, Lordship. This is 5 number 4, 5 number, it is clear, Lordship, that is for SC.
Oh.
Lordship, now your Lordship will have this recruitment process.
Now, who did they give it to? Who is the beneficiary of this? You said that they've given it, meaning no appointment has been made.
Appointment has not been made, Lordship. They describe it in the.
Then where's the question of giving it? Not
Lordship,
given it, so it's still vacant.
Lordship,
The post is still vacant.
posts are still vacant. Those are still vacant. Now your Lordship will have it.
So it is to be filled up by SC according to
by
this.
SC, Lordship.
Ah.
What they do it by an unreserved candidate, bringing him to that post. There are 8 backlog vacancies. They never consider that. Rosters are not at all maintained. No roster has been, we don't know, Lordship, how many posts are still vacant at that. I'll take your Lordship to the page number 49. This is the series. Direct recruitment method of assistant professors, Lordship. I'm an aspirant of the assistant professor. 49 is the page, Lordship. This is the recruitment where they have built this post.
Page 49.
49.
Yes.
This is a Lordship relevant at page number 52.
But this is of 2019.
August 2019, Lordship. That
So?
order was of that period, Lordship. For
Which
that reason,
order?
they have filled up this post, Lordship.
2, 3.
It was marked for the SC, Lordship.
No, just a minute.
Lordship will see an endorsement at 27.
You see, the writ petition was disposed of in 2023. Page 232.
Lordship, I'm showing that this post was earlier marked as SC,
No, I just want to know,
Lordship.
after this order was passed,
Lordship. There was
In
again an
2023,
advertisement.
where is the advertisement?
Lordship, that is the impugned advertisement. That
Which
is
one?
2000. That is the impugned advertisement.
2019,
2023, that is another advertisement. I'll take
where
you-
is that?
That Lordship, I'll see. 230 Lordship. Please.
Page 213.
13 Lordship.
This advertisement dated
6 July 2023 Lordship. Now
6
Lordship will
July
see-
13,
Lordship,
23, 6 July 23,
Lordship
6
will
July
see at
23.
page 230. Lordship will see at C, assistant professor. First for biotechnology is OBC, Lordship. So Lordship ought to have been SC in terms of their own meeting, in terms of the Guwahati High Court's order. Lordship, here it is OBC. Now I'll just demonstrate one more thing, Lordship.
No, wait.
How they,
And you are what candidate?
I'm an SC candidate, Lordship. I'm an SC candidate.
He has not
Post was
applied
reserved.
for.
Just a minute. Okay, so out here, biotechnology, biotechnology,
Lordship,
biotechnology is for one OBC.
one OBC. Now, Lordship, from a fair perusal of this advertisement itself, Lordship, it cannot be seen what is the roster which has been used. Lordship knows it very well when a selected candidate of less than 13 posts are marked, each post goes replacing one and the another. So the replacement theory is as has been confirmed by the R.K. Sabarwal's judgment. It says once the posts are filled up, each goes replacing the other. If there are two posts, L-shaped cadre would be applied. Lordship, here, my lord, it is a basically vacancy-based theory prior to R.K. Sabarwal's judgment. R.K. Sabarwal came in, Lordship.
I don't know this roster thing, you'll have to teach me.
Lordship, I take to the office memorandums, wherein, Lordship, it was replaced from
Show me.
the office memorandums. Lordship, I'll just demonstrate that recruitment process, that is at page number 49, I think, to your Lordships to have. And the relevant page, your Lordship.
No, but one thing, out here it is OBC. How do you, out here in page 222, it was for
Lordship,
SC. There was a mistake.
Roster was maintained as per their established rule. Lordship, their case is that it should be institutional base reservation. But as per the new rule, as per the department base, reservation should be made. According considering this.
What departmental base
Yes, Lordship.
and institutional base?
They said.
Let him, I'll come to my lords.
That is their contention. And Lordship, please to see their prayer, page 42. And here only one petitioner, earlier association approached this honorable court. They were satisfied, then they withdrew the petition.
No, Lordship, it was not Whittle. I've brought
Yes.
my lord's attention that the advertisements were.
Anyway, let us see the prayer. Yeah.
Lordship,
Lordship, page 42.
Yes.
A writ of in the nature of certiorari shall not be issued, setting aside cause the impugned rolling advertisement number so and so issued by the Registrar Assam University, and the same is not in conformity with the rules of reservation as prescribed in the office memorandum issued from time to time as well as per the judgment of the Honorable Supreme Court in case of R.K. Sabharwal. B. A writ in the nature of shall not be issued directing the respondent authority to forthwith comply with the order dated 14/6/2023 passed by the Honorable Supreme Court in so and so. Then C, a writ in the nature of mandamus shall not be issued directing the respondent authority to recall, resign, revoke, advisory number so and so. Then, as well
There
as
is
the
a point of
corresponding
de-reservation.
minutes of the
D.
meeting, taking note of the fact that there is no reservation of the post reserved for the reserved category candidate in particular year in the reservation roster for the post of assistant professor. Then a direction shall not be issued to the respondent authority to consider the representation dated 16/8/2023. These are the petitioner. Lordship, this is a writ petition filed by one individual person. And this is not a public interest litigation, Lordship. And now he said that he's, because his post was, earlier it was for SC, now it has been converted to OBC. And since
Lordship.
2023, Lordship, the recruitment in the Assam University is come to halt, Lordship.
So that is because of the orders passed by my lords. That specific chart showing. I'll take
Anyway,
photos.
this is only one writ petition now.
Yes,
Correct?
one
One
writ
writ petition now.
This is
One.
only one.
So it can only it can only relate to that biotechnology.
SC biotechnology.
So others we can fill up.
Yes, Lordship.
You fill up.
This is my.
But my lordship,
Huh?
That is my prayer, Lordship. We may be allowed to.
Yes, yes, you are allowed.
But
That's
my
why you are
lords,
allowed. But then-
there comes the issue. Lordship will have page number 52 for a moment. Your lordship will see in the other cases also, lordship, the post-based roster has to be followed.
No, no,
Now,
Mr.
two
Counsel,
affidavits
no,
come.
Mr. Counsel. Your case is only with regard to biotechnology.
Lordship, correct, lordship.
So the other departments have got nothing to do with you. Let them fill it up.
Lordship, they were filling up the post by vacancy-based system, lordship. That is what the affidavit says. They specifically spell out that we are not following the reservation policy. That is
Mr. Counsel,
specific.
that is none of your concern.
Lordship, but the mandate of RK Sabharwal has to be followed.
Maybe, but you see that you go and file a writ, you go and file PIL then. You go
Lordship,
file
I'm
PIL.
not for that, but my case also roster has to be
Yeah,
followed.
for your
Lordship.
case, we will
Lordship,
see.
has to be.
For your case, we will decide separately.
Lordship.
But not for the others.
Lordship, it will be pertaining to the entire department, Lordship. The entire department will have to follow one policy in respect of each and every post. He cannot do post based in my and vacancy based in other, Lordship.
That is
This
that
will
is a
again
different.
create
That
a
is no,
confusion.
that has nothing to do with you. That has nothing to do with
And
you.
Lordship, the Lordship's order, Lordship, I'll take my Lordship to the order wherein contempt has been drawn. It was specifically.
No, no.
asked
Now
that-
you see, your case is to set aside and call the impugn rolling advertisement so. As the same is not in. It can only relate to your claim for biotechnology, not for.
the backlog vacancy. It will
That
have
we
to
will
be
clarify.
concluded conclusively, Lordship.
Huh?
When the backlog vacancy is
Maybe, maybe.
50% of the post has to be filled from that backlog vacancy.
Maybe let them do it.
So Lordship will have page number 52 for a moment. I'll just demonstrate my parts, Lordship, that, then I'll leave.
And Lordship, so there is an act I have given to you, Lordship.
Hmm.
We said that the entire university is to be considered one institution. And reservation should be made as per the department, vacancy in the department. And we have not violated, entire policy has been taken care of, Lordship. And
No,
for-
let me see what is the policy followed by the
Central
university?
government, Lordship, that
Yes.
is what.
No, no,
I'm
by
saying.
the university, I think.
Yes, Lordship, this is
Eh,
in our affidavit.
You are asking for, you are asking to be a professor, what is it?
I'm for the
Assistant professor. Assistant professor in this Assam University.
Assistant.
Now Assam University follows what reservation policy? We'll have to see that
Lordship,
for this post.
Lordship will take up their affidavit.
And Lordship, the petitioner has not made any specific query with regard to himself. Lord.
No, anyway, it basically has to pertain to himself only, cannot pertain to anybody else.
Yes, Lord. And for his Lordship, this writ is an entire process for last 20 for 2 years. The entire process has been stopped. And the university is suffering for it.
Why is
Lordship,
it
at page number 245, that stand is clear, Lordship. And Lordship, in fact, my lord, I have my stand that post base has to be followed in all. Lordship, there is a UGC guidelines that all universities and educational institution will have to pay.
Anyway,
post-base
let us see your case.
Lordship,
Yes,
Lordship,
which page?
Lordship, 344. Sorry, Lord, 343, Lordship, their affidavit. And they've specifically spelled out that we are following the vacancy based process.
Affidavit in reply.
Lordship, in opposition, that was filed on. Lordship, the continuous page number is 343, Lordships, in my comparison.
343 is,
Continuous
pay,
comparison.
no, it's part of para 6
Yes.
of affidavit in reply filed by you. No, affidavit on behalf of the respondent number 234. Okay.
Yes, Lordships, that is what.
Yeah, you all use the wrong words. It cannot be affidavit in reply. It has to be affidavit in
be in
opposition.
opposition.
No, Lordship, here two affidavit filed by the Assam University. This is second affidavit.
Yeah, you make an additional
That's
affidavit.
additional.
Reply is usually filed by the petitioner.
I'm sorry.
So my Lordship, page 343, I'm referring Lordship,
343.
343 Lordships. Just from the middle, Lordship, if I may read, Lordship. That is the concluding point. Just in the middle, Lordships, page 343.
Yes. Yes,
Lordships, Annexure 7 has been marked in blue.
yes.
Lordship, thereafter, there still exists access and shortage for various categories. Hence, in the case of Assam University, the vacancy-based roster shall be applicable. for filling up the post till the representation of people belonging to the reserved categories and cadre reaches the prescribed percentage of reservation. Total in violation of the office memorandum of 97, which was issued pursuant to RK Sabharwal. There was a guideline issued by the central government.
The vacancy based roster shall be applicable for filling up of the post still represented. It is a prescribed percentage. So what is, so the vacancy based, what is the vacancy based roster?
Lordship, entire, Lordship, I direct my learned friend to
Read the entire thing.
entire paragraph. Lord. He's picking one line from here and one line from there.
Lordship, if I may complete, Lordship. The post-based roster prepared by Assam Union will only provide the
Read
ideal
from
number of
paragraph
reserve cadre
6.
that should be against the sanctioned number of posts. Again, it goes against it. However, till that time, recruitment may not be against the particular category for which the roster point is earmarked. Such deviations are as per law and as are not considered as de-reservation. I'll show my lords that Kulvinder Pal Singh Supreme Court judgment says after 1640, that cannot be any de-reservation. The vacancy-based roster shall cease to operate at
Well,
vacancy.
the de-reservation issue is gone.
Lordship,
De-reservation
after
issue is gone,
1640.
so why you're harping on that?
Lordships,
Now it has to
I
be
was-
filled up as per the, what is the reservation policy to be followed according to you, as per this affidavit? It is the vacancy based roster, is it?
it is the post-based roster.
Post based roster has to be
Post-based
followed.
roster has to be followed, Lordship. That is what.
So and the university has followed what roster?
Vacancy-based roster, Lordships. They are filling up vacancies as and when the vacancies are added. But Lordship, it's the post-based roster. What happens, Lordship? The posts are earmarked. One is for unreserved, second this and this. Lordship, once the posts are filled, each goes replacing the other. If there is a vacancy for that particular post, the person will be replaced by that. So in my respectful submission, Lordship, if there was a post for SC, it will always remain as SC, Lordship.
So we have to see. So whether whether the university has to follow the post based roster or the vacancy
Correctly,
based.
Lordships, correctly.
So if it is the vacancy based roster, you have got no case.
No case, Lordships. But
Okay.
in my respect,
If it's the post based roster, you have got a case.
that is what.
That is your
That
case.
is my case, Lordship. So office.
So
memorandum, I understand.
let us see.
Lordship.
So according to you, it has to be vacancy based or post based?
Lordship may come to page 356. We have given the chart.
Six is a judgment. I don't know. Your
Please.
pagination, my pagination is not. It's WPC 5200/2023.
Yes, sir.
Huh?
This
That-
is my part of my affidavit. 364 running page,
364.
364.
I thought it's 54. Okay, 64. 64, 65. 64 is office memorandum.
Yes, office memorandum.
Yes.
The title is reservation roster, post-based implementation of the Supreme Court judgment in the case of RK
Yeah,
Sabharwal.
okay, Sabharwal, yes.
Thereafter, Lordship may please to next page 365.
Yes.
We have given chart.
So you are following the post-based
Yes,
roster.
sir.
Lordship, the affidavit itself says, and we could demonstrate, Lordship.
Look,
that the
affidavit
particular-
is a different thing. Now we will see according to,
Lordship, let him produce.
let us see the, let
him
us see
produce.
the number of posts, let us see the, let us see who is to, how it is to be done, which post will have which post,
Lordship, page 365.
65 years.
The assistant professor, cadre strength 258, existing 226, vacancy 32, current vacancy 27.
Yes,
Then Lordship, SC, for post of assistant professor, SC, quota 38, present person 33, shortfall 5, backlog 1, embark 1 plus 4 is to 5. That was an advertise.
what, okay, shortfall 5, no, what do you mean, 1 plus 5, 4 is equal to 1?
Lordship, backlog 1, then
Backlog 1, then,
shortfall is 5, then it is made for 1.
no, it says 1 plus 4,
Yes.
what is this 4, where do you get this 4 from?
The total shortfall is 5.
Huh?
Shortfall is 5.
Shortfall is 5.
Then let's see, 1 is backlog.
Okay, so, okay,
One-
shortfall, so,
1 plus
so
4 is-
backlog is 1, out of the
Yes.
shortfall
Yes.
of 5, 1 is backlog.
Yes, sir.
Then
Then for SC,
ST,
first was SC, then second is ST, then third is OBC, then fourth is EWS. For ST,
no, again, this does not make sense.
Lordship, not at
This-
all.
this
Lordship,
we are
this is
not-
not
we
the
are-
roster that is followed. Lordship, this is totally vacancy based. Lordship will have para 171 guidelines says these.
No, wait, just a minute, you're not making sense.
Correctly, Lordship, it doesn't, Lordship, doesn't. make any sense.
ST backlog shortfall is 5.
Yes, Lordship.
Backlog is 2.
Yes, two.
Then why is it here 2 plus 2 is equal to 4?
Lordship, it has not been uploaded in their official website. Guideline says they have to upload the rosters in the official website. I'll take my lords to the particular page, guideline by the UGC saying you'll have to upload the roster in the websites.
Yes.
Lordship will have page
Okay,
one-
tell me.
Lordship, page
You're not
170.
making sense, Mr. Council.
Not at all,
With
Lordship, it is a
365,
vacancy base, basically, Lordship.
the 365 is not making any sense.
Correct, Lordship, cannot be Lordship, because once a post-based roster is there, Lordship, every confusion goes to nullity. Lordship will have 171 for a moment, Lordship. This is what the prescription is. RK Sabharwal says this has to be followed. And once RK Sabharwal comes into play, Lordship, the entire thing goes, Lordship.
171.
171, Lordship. For direct recruitment on all India basis, I open the
171, yes.
of my writ petition.
Yes, yes.
This is the roster, Lordship. In cadres having less than 14, this is the roster. Each post has been marked unreserved,
Cadre having less than
13 posts, Lordship.
13 posts.
Lordship.
But here it is more.
No, Lordship. Here there are 2 posts only. Only in the case of biotechnology, there are only 2 posts.
2 posts of
2 posts of biotechnology assistant professor, Lordship.
For a moment, I'm representing the UGC. In this particular case, it will not be department wise as to how many posts are there.
Has to be
Because
subject wise.
there is a 2019 act which has been produced by my level senior just now before. This particular act provides that an entire central educational institution is to be taken as one single unit.
Okay.
So once it is taken as one single unit, the question of biotechnology department or the physics department
Being separate does not arise. It does not arise.
to be one single unit.
Ha.
So according
So-
to
so-
the
Ha.
the central government has framed the guidelines as per RK Sabharwal. It says that it has to be filled up on post-based roster system, but the entire institution has to be taken as one single unit.
Okay.
So the post will be not assistant professor biotechnology. It will be assistant professor of all the departments. How many?
SC, ST and all that. Huh?
And it is, whatever the number is, according to the representation, it has to be filled up. It has to be taken as one single unit. It is not to be taken up department wise.
Okay.
So, Lordship, our
Section
stat-
3 of the act.
Section
Section-
3 of the act, Lordship.
Notwithstanding anything in any other law for the timing in force, there shall be reservation for the post in direct recruitment out of the same sanction strength in teacher's cadre in a central educational institution to the extent and in the manner as may be specified by the central government by notification of the official gazette. 2. For the purpose of reservation for post, a central educational institution shall be regarded
As one unit.
So my lords, post this, their own affidavit, Lordship is having that affidavit at page number 246 of the same affidavit. Lordship is,
No, so
Post
there is no question of your biotechnology
no, Lordship.
being
This-
considered
If
separate.
I may read it again, Lordship, there is a teacher's cadre. Teachers will be given separate subjects. Lordship, if I may read it again,
What is the assistant professor?
assistant professor is the cadre of the category of recruitment, Lordship. Wherein, Lordship, it has to be subject-wise. I'll take my Lordship 2 orders just for my Lord's satisfaction. First, I'll read this provision again, Lordship, it's at page 278.
Two 78. Yes,
Notwithstanding, if I may read, Lordship.
yes.
3L,
270.
278 is 3L.
Huh?
Clause 3L. 3L.
Whether the catch-up principles are tenable.
Oh, Lordship,
Is it this?
this guidelines.
No.
Then I take my Lordship
278,
to their page 246, where the stand is very clear.
246.
246.
You should paginate your file with my file. Otherwise, it's
But
it's
this
a
is not
problem.
My affidavit, I'm sorry, Lordship, this is not my affidavit.
Huh?
It was filed by the respondent UGC.
Maybe, but then you see, pagination is done. Now 248 again is different.
Lordship,
248 is again this.
246, if I may.
246 is again part of an affidavit.
Lordship, that is failed, Lordship, that is their understanding, Lordship. At first line, Lordship, it is dated July 1997. First line.
Mr. Counsel, 246 for me is this. This. It says here, para 197.
There is some error. There is some error because our
Two affidavits,
affidavits are tallying.
Lordship.
Our affidavits are telling. You two are telling.
Tallying.
But mine is, but so, do I have to come down there and mark my
Lordship,
thing?
I'll ask my brother to help my.
Yeah, देखो.
So you are the legal guild. It's 246, yeah. I think you have counter affidavit. You see fine.
Very difficult this way. We'll never be on the same page.
Last month is not. Last month is not. You are affidavit, are there, UTC. Yeah, 246.
Affidavit is starting at page number 391. Lordship, the initial page numbering of the affidavit in the court record is also the same, but subsequently
They have been changed.
it has been changed. So that is why we were not on the same page. I have taken out the page number now.
Like.
Has been struck off in the court record also and then repage number.
Lordship, will go by the repetition first because I'll clarify my lords on the office memorandum, which clarifies the post-based reservation has to be followed throughout, Lordship. I'll just point this part, Lordship, that page 246.
Page
Said-
394.
394, Lordship.
394.
This is para 9, 10.
Eight above, Lordship.
Eight.
The very first one of
Okay.
the eight.
Para 8 starts from 393.
394, Lordship. Para number 8, that as per the instruction issued by the Government of India, Department of Personnel and Training, New Delhi, Office Memorandum this and this dated 2nd of July 97, post-based roster is applicable. That is the stand of the UGC. Here also, Lordship, the post-base is applicable. And so my lords now, it connects the dot
Post-based roster is as per the
as per that.
R.K.
97
Sabharwal.
R.K. Sabharwal, Lordship. That has to be applied. Post-based roster is applicable to all granting need institutions, central universities getting this and that. Now, this point is very much fortified by my writ petition, goes to 1997.
whose affidavit is this?
UGC Lordships, Granting Commission. We
Oh,
made them a
okay.
party.
So post-based roster is applicable,
Applicable,
correct?
Lordships, throughout the
Ah.
country, Lordships.
Then
Then my lords will have one order of our High Court, wherein Lordship interim was issued on this point itself.
page,
Order dated 12/9/2023 of my lords order sheets. 12/9/2023 of the same case. Lordship.
of the
Order
same?
passed by this court, Lordship.
No, where? Which page?
Lordships, the order sheets.
Order sheets, order sheets.
12/9/2023. Here, Lordship, a detailed clarification was asked for
12/9,
2023, Lordships. 12/9/2020.
yes,
Lordship, if I may read the,
yes.
according to the petitioner, the relevant portion, Lordship.
Haha.
According to the petitioner, it is that as per the provision laid down by the Honorable Supreme Court in the case of R.K. Sabharwal, this and that, the reservation is to be implemented on the basis of whose reservation and not as a running roster. Meaning thereby that whichever vacancy in the roster point has fallen vacant, the recruitment is to be made against that vacant roster point, and the recruitment would have to be against a particular category for which the roster point is earmarked. The grievance raised by the petitioner is that since principle has been violated in the renewed recruitment process initiated by the respondent in the Assam unit subsequent to the order dated 14/6/23 of this court in WPC 7077 of 19. In the said writ petition, the proceedings were closed on the basis of statement made by both the parties that the de-reservation process which was sought to be initiated has been withdrawn, meaning thereby there would not be further de-reservation. And accordingly, the court allowed the recruitment process to be carried out. This is important. In other words, it is sought to be understood that if the de-reservation process has been withdrawn, the recruitment would be made by taking note of the roster points earmarked for the particular category, and it would be a recruitment of that particular category alone. To examine.
But then this particular category alone,
Lordship.
this thing that has been stated by this court, whether that is based on anything.
Lordship, that is what Supreme Court's para 3 articles for, very clear, on the same point. Exceptionally on that same point, that earmark post, so that there is neither excessive, neither short work. If the posts are earmarked, I'll take my lordship to the Supreme Court. I'll just finish this part, lordships.
Hmm.
To examine the grievance raised by the petitioner, the respondent in the Assam University to produce before the court the roster post point maintained by the subject wise where the recruitments are being initiated, and in the roster point, which of the roster points are presently vacant for which the recruitment is to be initiated, and which of the roster points are presently occupied. Further hearing would take place upon production of record as it is a status quo on the recruitment. Lordship, this status quo, lordship, was violated. We had filed a contempt. They issued another recruitment without changing the rosters. The artist.
Now we'll have to see whether that particular category would mean it can be done only for that biotechnology.
So lots,
Correct.
lots.
Otherwise, what this order appears to show is that biotechnology can be considered separately.
Separately, lordship.
That is your case.
That is my case, lordship. Para 3.
So he's relying upon this order of this court. But then whether this order has been made by while considering this act is another issue.
Was not
Yes.
there.
That is the case, no? That is
Not there at that point of time.
okay. That act was not there at that point of time. No. It was there.
It was not produced.
This order was of 23.
23.
The orders of 23.
Not produced.
It is not produced. So whether because that is what he's relying upon. He's saying that the biotechnology
Subject.
would have to be considered separately. The roster point for that subject
That
in terms of the order.
Order.
But then whether this order can be said to be proper
Correctly. I'll
in
just-
the without considering this act.
Lordship,
That's the
para
issue.
5 of RK Sabarwal, I just show my lordship.
Para
Why
5.
it is category wise.
Sure.
That is good. Lordship, please the copy of the judgment. Lordship.
Where is that? It is here. Okay, R.K. Sabarwal. Yes.
Para 4, if I may
Just
take.
a minute. Just a minute. Para 5.
Para 4 for a moment, my
Para
lord.
4. Okay. Yes. Yes.
When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve points, it has to be taken that the posts shown at the reserve points are to be filled from amongst the members of reserve categories, and the candidates belonging to the general category are not entitled to be considered for the reserve post. On the other hand, the reserve category candidate can compete for the non-reserve post, and in the event of the appointment to the state post, the numbers cannot be added and taken into consideration for working out the percentage of reservation. So
Correct.
they cannot add it up also.
Correct.
Article 16(4) of the Constitution India permits the state government to make any provision for the reservation of appointments or posts in favor of any backward class of citizen, which in the opinion of the state is not adequately represented in the services under the state. It is therefore incumbent on the state government to reach a conclusion that the backward class for which the reservation is made is not adequately represented in the state service. While doing so, the state government may take the total population of the particular backward class and its representation in the state services. When the state government, after doing the necessary exercise, makes the reservation and provides the extent of percentage of posts to be reserved for the state backward class, then the percentage has to be followed strictly. The prescribed percentage cannot be varied or changed simply because some of the members of the backward class had already been appointed, promoted against the general seats. As mentioned above, the roster point, which is reserved for a backward class, has to be filled by a way of appointment promotion of the member of the state class. No general category candidate can be appointed against a slot in the roster which is reserved for the backward class. The fact that considerable number of members of the backwards have been appointed, promoted against general seat in the state services may be a relevant factor for the state government to review the question of continuing reservation for the state class. But so long as the instructions rules providing certain percentage of reservation for the backwards are operative, the same has to be followed. despite any number of appointees belonging to that backward class against the general category post, the given percentage has to be provided in addition. We therefore see no force in the first contention raised by the learned and was issued. That was
This
early point.
does not have any relevance to
Lordship,
this
the
case.
second paragraph, Lordship. The second paragraph, where the slots has to be marked.
Huh?
Marking of the slot, that is the second point. We see considerable force in the second condition raised by the learned counsel for the petitioner. The reservation provided under the impute government exemption are to be operated in accordance with the roster to be maintained in each department. The roster is implemented in the form of running account from year to year. The purpose of running account is to make sure that the scheduled caste, scheduled tribes, and backward class get their percentage of reserve force. The concept of running account as the impune instruction has to be interpreted that it does not result in excessive reservation. 16% the posts are reserved for members of the scheduled caste, backward class. In a lot of 100 posts, so this is important. Those falling at serial 1, 7, this and this has been reserved and earmarked in the roster of the scheduled caste. Roster point 26, 76 are reserved for the members of backward class. It is thus obvious that when recruitment to cadre starts, then 14 posts earmarked in the roster are to be filled from among the members of the scheduled caste. To illustrate first point in a cadre.
How does it say? It is thus obvious that when recruitment to cadre starts, then 14 posts earmarked
In the roster.
in the filled up from among the members of the scheduled caste. From where does he say that?
Lordship, from the 100-point roster, 14% are marked for the SCs. So that gives a
Just
percentage
a
of
minute.
14%, Lordship. In 100-point roster, Lordship.
It says 16. Acha, okay. 2 are for. No.
Lordship, it's on
Where
the
does it say 14% are earmarked for the scheduled caste?
Lordship, these points are 1, 7, 15, 22. If we calculate these points, these are the earmark posts for the SC category.
Okay.
So if it
These are
total amount,
14.
these are 14.
Okay,
Lordship, at the
14.
90.
Yes.
So when these posts are earmarked for SC categories, Lordship, only persons falling from the SC categories will be entitled for that post, and it goes by replacement. It is thus obvious that when recruitment to cadre starts, then 14 posts earmarked in the roster are to be
Correct.
filled from among the members of the scheduled caste.
Yes.
To illustrate first point in a cadre must go to the scheduled caste, and thereafter the C class is entitled to this and this post till 91 Lordship. When the total number of posts in the cadres are filled by the operation of roster, then the result NVC by the impune instruction is achieved. In other words, in a cadre of 100 posts, when the posts earmarked in the roster for the scheduled caste and backwards are filled, the percentage of reservation provided for the reserved categories is achieved. We see no justification to operate the roster thereafter. The running account is to operate only till the quota provided under the impune instruction is reached and not thereafter. Once the prescribed percentage of the post is filled, the numerical test of adequacy is satisfied, and thereafter the roster does not survive. The percentage of reservation is desired representation of the backward classes in the state service and is consistent with the demographic estimate based on the shifting boundary, but represents a figure with due application of mind. Therefore, the only way to assure equality of opportunity to the backward classes and the general category is to permit the roster to operate till the time the respective appointees, promotees occupy the post meant for them in the roster. The operation of the roster and the running account must come to an end thereafter. The vacancies arising in the cadre after the initial posts are filled will pose no difficulty. As and when there is a vacancy, whether permanent or temporary in a particular post, the same has to be filled from among the category to which the point belong in the roster. For example, scheduled caste person holding the post of roster 1-7 retire, then these slots are to be filled from among the person belonging to the scheduled caste. Similarly, if the person holding the post at point 8 to this and this retire, then the slots are to be filled from among the general category. By following the procedure, there shall neither be shortfall nor excess in the percentage of the reservations. Then Lords will be pleased to have this office memorandum of 1997.
So that is okay. So then what is wrong?
Lordship, the roster is not there, Lordship. There is no roster. Points are not here.
No roster points have.
No roster points. They are not following the post-based reservation. That is the whole difficulty. And my Lord's order of 49/2023 specifically says, R.K. Sabarwal is followed, you give me the subject-wise.
Subject wise might not be possible, but
May not
then
be, Lordship, but
the roster points will have
roster
to
points
be.
have to be. Lordship, if I may.
That
put
is
my
your
Lord's-
case.
Lordship, if I may, for a moment, my Lords will have page number 49, Lordships. 49 is
Huh?
series 49, Lordship. And
Page 49.
page 49, that is annexure 3 series, Lordships.
Page 49. Page.
Page 49, Lordship, annexure 3.
It's 49. Page 49. Page 49 is
Got
the
it. Post
Assam
of-
University enrollment, employment notification.
Reservation register and recruitment details, annexure three, Lordship. Page
Annexure
number
3.
49. Annexure
Annexure 3, okay, 49.
49, Lordship.
Yes, yes.
Reservation register and recruitment details for the post of assistant professor. Down below, my lord will mark that this is for the month of August 2019. Lordship will have page number 52,
Yes.
point number 23, Lordship, serial number 23, biotech
Serial number
23, Lordships.
23. Yes.
Biotech, Lordship will mark Lordship as
Biotech, yes.
biotech. Lordship, on the right hand side, your Lordship will see the under the column filled as unreserved or as reserved for SCNC. Lordship,
Yes,
here it
unreserved.
was unreserved.
Huh.
Now my Lordship will have at page number 59. Lordship 69, I'm sorry, Lordship.
Yes.
My Lord is having page 69.
Yes.
See, point number 3 from above, existing post converted, de-reserved, leave vacancy field.
Existing post converted, this is
De-reserved,
summary, reserved,
vacancy
vacancy
filled.
filled, yes.
Lordship will see it in the column of SC,
Yes.
number of posts have been de-reserved. Lordship. So Lordship, in terms of 16(4)(b), that is imposed. Now my Lord will see it down below in the same page, summary of category.
Yes, at the bottom.
Lordship, at the bottom, summary of category wise earmarked and backlog vacancy for the post of assistant professor. Lordship will
Yes.
see in column of SC, that is the first column, Lordship.
Yes.
Right hand side, your Lordship, at column number 5, biotech is there.
Yes.
Means there is a post of biotechnology. Lordship, but here what was given, it was given to an unreserved candidate.
Was given to a.
Unreserved candidate at page number 42, Lordship has seen, Lordship. At
It
serial
has not
number
been
20,
given. It has not been given. Where is it been
Unreserved,
given?
Lordship. That has been given to an unreserved candidate. At
40,
page number 52, Lordship, which I have just shown.
52.
52, page number 52. And serial number 23, the biotechnology post, even there was a post, earmarked for the biotechnology under SC category.
52.
Lordships. 23,
Unreserved.
Unreserved. Lordship. Here it shows that there is a post under the SC and they are above at the serial number 3, existing and de-reservation, they are continuing with. So Lordship, it is that Vincent and caprices, they will give it to someone, they will de-reserve the post for the general, that is my case. So if the proper roster is maintained, Lordship, we will come to know which the next roster is about to. It might be for a reserve candidate, it might go for an unreserved. In that case, Lordship, the correct.
But this is of 2019, Mr. Council.
Lordship,
That this is prior to your writ petition also.
correctly, Lordship, I'm just demonstrating how they are following the roster.
No,
They are
that is the different.
de-reserving.
Now, no.
Lordship,
That is of that period.
Lordship,
After the, you filed your writ
in
petition
23, Lordship,
in, huh?
20,
In 23.
these include notification, Lordship, that were set aside. There the issue was this.
You see, that the issue there was this, that it was going to be filled up by UR instead of a reserve category because it was de-reserved.
Lordship, this affects me, Lord, because the reason that unreserved post, they cannot de-reserve it. 16.
No, so now it has been reserved again. It has been reserved for SC.
Now, Lordship, 2023, this has been marked for OBC. I've just shown. my
Okay,
Lordship,
OBC, it has been marked for
So
OBC.
Lordship, it, at their whims and caprices, they are giving it to somebody. The entire roster is this, Lordship. Lordship, I'm just facing Kulwinder policy. 16(4)(c) categorically says after coming up 16(4)(b), that cannot be. Supreme Court clarifies, Lordship. Equal rights. Kulwinder policy. Here.
16?
Lordship, para number 15 for my lords.
Para 15.
Para 15, Lords. Very specific, categorically on this spot.
Para 15.
Para 15, page
Yes.
539.
Huh?
Page 539, Lordships.
Page 539, yes.
By perusal of section 7, it appears that as a general rule, there is a bar on de-reservation of the post reserved for the scheduled caste candidates. However, subsection 2 provides an exception to the general rule by laying down that in the public interest, the authorities may pass an order in writing de-reserve the seats reserved for category candidates belonging to the scheduled caste category. Lordship, this is important. After insertion of clause 4B in Article 16 of the Constitution by the 81st Amendment, de-reservation could not have been done. Under Article 16(4)(b), the Constitution of India, unfilled vacancies reserved for the scheduled caste scheduled candidates are to be carried forward independent of ceiling of reservation of 50%. The seat reserved for scheduled caste and scheduled tribes categories are to be filled by only by specified category. Therefore, the High Court was right in finding fault with the de-reservation of the 7 posts. Here, to Lordship has seen 8 posts has been de-reserved.
Anyway, now whether how does this the only thing now is that the SC post should have been reserved for SC only. That's
SC
all.
only, Lordship, as
That-
per the
that's your
post.
case.
And the following of that post
Now we have to see whether that post
has been
falls within for SC or for OBC.
SC or those. Lordship, but very categorically,
Huh?
in the Lordship's order, the meeting of the minutes, they specify that one post of at point number 5 for assistant professor is one SC. This
In that order of this court.
Lordship, this at page number 222, Lordships. Their
220.
own meetings at point number 5,
200.
page 22, 222.
Yes.
Lordship, down below the column which they have specified,
Ha.
post of reservation, assistant professor, one post is for SC. But what they do, Lordship, in the impugned advertisement, they make it for biotechnical. Lordship, it should only be done in case they follow the proper roster in terms of the guidance. Now, Lordships, two more important points at page 114 of my red petition, Lordship.
114.
14, Lordships.
114, yes.
Lordship, this is an office memorandum of 25th April 89. Subject matter, I'll not cover
Office
my lords.
memorandum dated 25 April, yes.
Lordship, I'll just read the subject line. I'll take my lords to the important on the next page, Lordship. That is
Yeah.
ban on de-reservation in direct recruitment to vacancies under the government. Next page, my lords will see. 7 December 2009. That is at page number 115. Office memorandum.
Yes.
Lordship, I'll just read the first paragraph. The undersigned is directed to invite the attention of this department OM number this and this, whereby pro forma for sending proposal for de-reservation of reserve vacancies were prescribed. In view of the fact that a number of developments like creation of separate national commissions for the scheduled caste and scheduled tribe, replacement of vacancy-based roster by post-based, ban on exchange of reservation SC/ST have taken place, it has become necessary to modify the same pro forma. Vacancy was also done away. De-reservation was also done away by this office memorandum of 2009, Lordship. Now, my lords, very important is page 178 for my lord's consideration.
178,
178, Lordship.
yes.
Lordship, this is issued by the Minister of UGC, University Grant Commission, dated 19th of October 2020. Lordship, the relevant part is at para number 3. Lordship, now when the roster has to be followed, it has to be uploaded on the website. That is what it says. If I may read, Lordships, you are required to display the reservation roster, which is to be uploaded at regular intervals on your website as per instruction issued by the government of this and this, dated July 1997. 1997 is the same OM, Lordship, which brought in R.K. Sabharwal post-case. And Lordships will have the final thing at page number 1997, office memorandum, which brought in the R.K. Sabharwal's issue. Page number 123. Lordship. This is
120?
123, Lordship. 1997 office memorandum, which says you have to upload it in the website. Roster has to be uploaded. In my case, Lordship, never it was uploaded. No roster has been seen in the website.
123.
Lordship, this is the office memorandum which I was talking in the last annexure. That is it.
Where does it say?
Lordships, the undersigned is directed to say that under the existing instructions, vacancy-based roster have been prescribed in order to implement the government jobs policy reservation.
Vacancy based.
Lordship, I'll just come. The case. to implement the government's policy relating to reservation of jobs for the scheduled castes, the scheduled tribes, and the other backward classes. The application of reservation on the basis of these roster was called into question before courts. This is important, Lordship. The Constitution Bench of the Supreme Court in the case of R.K. Sabarwal, State of Punjab, as well as J.C. Malik versus Ministry of Railways, has held that the reservation of the jobs for the backward SC should apply to posts and not to vacancies. The court further held that the vacancy-based roster can operate only till such time as the representation of the people belonging to the reserve category in a cadre reaches the prescribed percentage of the reservation. Thereafter, the roster cannot operate and vacancies released by retirement, resignation, promotion, etc. of the person belonging to general and the reserve categories are to be filled by the appointment of persons from the respective categories so that the prescribed percentage of the reservation is maintained. The court also held that persons belonging to the reserve categories who are appointed on the basis of merit and not on account of reservation are to be counted towards a quota meant for reservation. With a view to binding the policy of the reservation in line with the laid down by the Supreme Court, it has been decided that the existing 240 and 120 vacancy-based roster shall be replaced. Lordship, everything has to be replaced by the post-based rosters. Lordship, at para number 3, very specific. All ministries, departments, and concerned authorities are requested to prepare the respective roster based on the principles of elaborated in the explanatory notes given in Annexure 1 to this office memorandum and illustrated in the model roster annexed to this office memorandum as Annexure 2, 3, and 4. Similarly, the concerned authorities may prepare roster to replace the existing 100-point roster in respect of the local recruitment to Group C and D posts on the basis of the same principle. The principle for preparing the roster elaborated upon in the explanatory notes are briefly recapitulated below. Since reservation for OBC does not apply in promotion, there shall be separate roster for direct recruitment and promotions. The number of points in the roster shall be equal to the number of posts in the cadre. In case there is any increase or decrease in the cadre strength in the future, the roster shall be expanded and contracted correspondingly. Cadre for the purpose of roosters shall mean a particular grade and shall comprise the number of posts to be filled by a particular mode of recruitment in terms of the applicable recruitment rules. Thus, in cadre of say 200 posts where the recruitment rules prescribe a ratio of 50-50 for direct recruitment promotion, 2 roster, one of the direct and the other for promotion, each comprising 100 points shall be drawn up on the lines of the respective model rosters. Since reservation does not apply to transfer, where the recruitment rules prescribe a percentage to the post filled by the method, such post shall
Anything
be-
else? The same thing you're reading all over.
Lordship, this is what para 5 of R.K. Sabarwal says. Totally in consonance with that. And this was brought in and it has been followed throughout the country. Lordship, the model roster that has been prescribed, that is at page Annexure 1, which I was just citing it through the page 129, Lordships. This is part of the state office memorandum, and this is how demonstration has been given, how the roster has to. Each category has been marked on the right-hand side, unreserved, OBC 1, this. Lordship, it operates in such a manner. Once these 100 points are filled, Lordship, we come to know how many slots in respect of which categories are there. So each goes replacing. If there is an appointment or retirement of a person from a safe post, it will go replacing. That is what the R.K. Sabarwal said. So Lordship, it is very logical and it has to be followed. That is why the mandate was given and this office memorandum was issued to all the departments to change it from vacancy based to roster. In Assam, it came in the year 2012, Lordship, by bringing in the amendment to the Act of Reservation of Vacancies with Submission Posts. And for our Lordships, in my case, page 140, that is Annexure 3. 44. L-shaped roster in respect of model roster of less than 13 posts, Lordship, this has to be followed. There is a specific guideline for this. How it has to be.
How does it work, this one?
Lordship, first there will be a roster, Lordship, it has to be a book, Lordship. Generally, what I see in the department, they follow a book. They put up spaces in each and every post. If there is a vacancy, they just keep on running an account. First, point number 1 would be filled, second, third, fourth, fifth is a point for the reserve category candidates. STP would come in. 7 will go for an unreserved, 8 will go, 9 will come for an SC candidates, and 14 will come for ST Hills.
For?
ST Hills, Scheduled Tribe Hills. After 14, it starts from 1. From the first post again would be this. This is how it operates. So it goes as a running account, which is what the Supreme Court says. So Lordship, this is what the mandate says, and Supreme Court is very categorical. After R.K. Sabharwal, that has.
But yours is, according to you, its cadre strength is less than 13.
Less than 32.
But according to them,
Lordship, that is what they will have to, because they had not been following the roster. We never even know, Lordship, that where do we stand. They had been giving posts to OBC, sometimes they change it. There were 8 posts. Totally, they have de-reserved it. De-reservation could not have been done. So that is in total violation. The department is. not
yes, madam,
functioning.
one thing. Now, according to him, his cadre strength is less than 13 biotechnology. But according to your act, since it has to be considered as one unit, so all the cadre strength of all the subjects would have to be made into one, amalgamated. If it's amalgamated, then this roster point for 13 will not be applicable.
No, no.
Then what will be applicable? 100.
100
Lordship,
points.
that will have to be worked upon by the university.
So how many roster points are there?
Lordship, if I may take my lord to the said paragraph which my learned colleague was relying upon, notwithstanding.
Where? Page?
Lordship, that act which my
Act,
colleague was.
yes.
Page 426, my lord's compilation. 426, running page of my lord's letter. At 3L, Lordships,
3L.
3L. 3-1, Lordships, I'm sorry.
3-1, yes.
Notwithstanding anything in any other law, for the time being in force, there shall be reservation of post in direct recruitment out of the sanctioned strength in teachers' cadre. Lordship, in teachers' cadre, Lordship, that can be 2 things, Lordship. Either for the entire cadre of including associate professor, assistant, and the other professor, or it could be subject wise. Lordship, it's not that specific that it cannot be subject wise at all.
It has been defined. Above that, teachers cadre. L.
Lordship, it's there, Lordship. So it's
Yes. Means the
Means
class
the
of
class-
all the teachers,
all teachers of a central education.
regardless of the branch of study or faculty.
who are-
Who are remunerated at the. same-
So,
Lordship,
so
that- in
so
that case,
then it comes beyond.
beyond that. Correct.
So on
That
the,
will-
but now his question is, where is the roster point?
that is
Which is,
not
which post is reserved for SC? Which post is reserved for OBC?
Page 336.
Now I hope my 336 and your 336 is similar.
Affidavit, Lordship,
336.
the affidavit in reply filed by the university.
Affidavit in reply, filed by,
Assam, respondent number 2, 3, and 4.
okay, 337A in mine. This is by Pradosh Kiran Nath,
Yes, sir.
Okay.
The registrar of Assam.
337. Yes,
It was a part of annexure 7.
yes,
We have given the details.
Huh?
Details have been given.
show me.
Lordship, assistant professor,
At,
page 366.
360.
366.
Three 66. Yes,
This is the position of assistant professor.
yes. Yes.
Column 1 is sanction strength 5, main in position 3.
Sanction strength of, that is of what?
Assistant professor.
Assistant professor. Department has not been mentioned.
Okay,
this is
sanction strength, okay, man in
vacancy
position
based.
3.
It's a vacancy base.
Huh?
Vacancy has been shown here.
This is vacancy based, Lordship. Absolutely. And man in position 226, man in position comes
Their
from. the-
sanction strength is 258, man in position is 226.
Vacancy 32.
So where is the question of sanction strength being 5 and man? This is what? This is subject wise or what is this?
It is, but it is not written here.
This is, you see, because this is page 366. On top it says assistant professor.
Assistant professor.
Sanction strength 258. Man in position 226.
2 to 6.
Vacancy 32, current vacancy is 27. And then out here on the left it says sanction strength 5. It cannot be sanction strength 5. Sanction strength is already 258.
No.
So this is, so it's either discipline wise or what?
It is discipline wise.
Discipline wise.
It is
Ah,
not
so
written.
what do you want to show?
No, Lordship, here. Lordship, please to see, 1, 2, 3, 4 is vacant.
Ah,
It is
but it is reserved for whom?
for SC.
SC. Okay.
Then next vacancy is for OBC. Already advertised SC. Then OBC to be advertised. Remarks 3.
But which subject?
Subject is not written here.
And how do we know?
Because we are following as per the university entire.
Mr. Counsel, you see, you might be following something. But the issue is now to fill up the post of this biotechnology, which he wants to apply for. Now, whether that belongs to an SC or not, where do I get that? Whether it belongs to OBC or whether it belongs to a reserved category, where do I get that?
In advertisement, it is marked for OBC.
Huh?
In advertisement,
Advertisement has to be based on something, no?
Yes.
Cannot be on the whims and fancies of the powers that be.
Lords, we have taken a specific stand. This annexure which they had been submitting, it has not uploaded in the website as well. This is a manufactured to say.
No,
For
no,
the
what,
reason-
this Annexure 7.
Lordships, it was
No.
never uploaded in the website. We
Anyway,
have taken a specific stand. that the-
How does it, this does not address the issue anyway.
Lordships, because the guideline says, when you follow a roster in terms of guidelines of the central in university educations, you'll have to upload the roster in the website. That's what my lords have seen the office memorandum of 19th October.
No, no,
2020.
whatever it is, this is not the,
Lordship, if the roosters are not given.
this is not
they
the
cannot be-
roster.
Lordship, that is what, this is the vacancy base. They have to upload in the website.
There is-
also.
this is
Even
not
if
a
it is
roster.
wrong,
There is
even
not
if
a
it is wrong, they
There's
will have to-
nothing to show which post will go to whom.
Correctly, Lordship, that cannot be
It's-
shown because.
it's not-
Post basis roster is.
It's only
quite
names
lengthy.
are given.
his names are given.
Then how do we know that whether that post is for
This is what the university
unreserved
is
category or for SC or for OBC?
Lordship, it is not for specifically biotechnology. It's for all other departments, including all. So Lordship, we never know where do we stand. And the
That's right. So what
university
has
is-
happened to the advertisement?
Lordship,
That is
thereafter,
the-
there was a stay.
He kept in
But
hold.
they, no, Lordship, I'll say, here I'll beg to differ, Lordship, from my brother. Lordship, contempt was filed for the reason they went ahead with that advertisement. That is 5200. That is violation of the code. Specifically, advertisement was issued. And Lordship, 344, their paragraph, it says, at this stage, it says neither necessary nor desirable for the university to advertise as per the earmarking of post. They deliberately say that we are not going for earmarking of the.
But they have to earmark.
Definitely, Lordship, roster of the RK Sabharwal has to be followed throughout the country. This is a mandate, Lordship. Presently, this is what the working is.
Yes, Mr. KL, what to do?
Lordship, for the time being, for his post may be kept vacant, we may be allowed to.
No, no,
Not say
but then the
others would
problem is
suffer,
then where will his post be?
Exactly, Lordship. I
where,
don't know where I stand.
where are you going to put his post?
Now, for his post, Lordship may decide accordingly.
No, I cannot decide. You have to do the exercise.
No,
Lordship,
as per
roster
our,
has to be
as
there,
per our,
seriously.
Lordship, that exercise was taken by the university, the post for biotech is reserved for OBC. As per the new rule and in affidavit, we have clarified everything.
Okay, but show me where is the post-based roster you have made. You see, once you can show the post-based roster and you have identified the post for a particular category, then we will follow it. If he doesn't come within that, then he doesn't come.
Exactly, Lord.
Simple as that, nothing can be done. But you have got to make a post-based roster. Now, for those other persons who are going to be appointed, where are they going to stand? And for the next person, supposing you make for ST. Now, okay, as per your we allow. Then for when he retires or he gets promoted, when is the next ST going to come in? In is it going to be basically a vacancy based roster or what?
Correctly, Lordship. It has been vacancy.
Approximate,
Lordship.
we should take the matter on the next Wednesday.
Ah.
I'll,
You see,
What is
very
the-
simple. Just tell them make a post based roster. Yes, madam. What? Let me hear her. I have heard you basically.
no, records, I'll produce the records.
No, I don't want the records.
No, how it is in.
I just want the post based roster. Nothing else is required.
Then maybe taken up tomorrow, today.
I can take up any time. You just bring the post based roster. Once you have the post based roster showing the post,
Earmark post, Lordship.
the post earmark for the various categories, that's enough. End of the matter. Entire thing goes. He can challenge the
Definitely,
roster.
Lordship.
That's a
That would be
different
the
issue.
subsequent issue.
That's a
That would
different
be
issue.
different issue, Lordship.
So you that is the only thing. Nothing.
I'll
There's
clarify.
nothing to decide otherwise.
I'll clarify tomorrow.
And then there's nothing to decide.
Correctly, Lordship. Mandate has to be followed, Lordship. That we are on.
Let me ask, madam.
Lordship.
My submission is very limited because I'm a common party here. And what are the UGC guidelines relating to reservation? I am here only to apprise this honorable court to that effect. Now,
To what effect?
to that effect that what is the reservation policy or what roster base
So now it
needs
has
to
to
be
be.
followed by the central university.
Ah.
So my submissions are only two. Firstly, post-based roster has to be followed. And secondly, it cannot be department-wise, single department wise separately. It has, the entire central educational institution has to be considered as one single unit as per the 2019 Act.
So you cannot reserve a particular post for a particular subject.
Yes, ma'am.
Correct?
Yes, ma'am.
That is your case. You cannot, then if you cannot reserve a particular post for a particular subject, how are they reserving it for OBC?
Lordship, this is something that the university will have to satisfy this honorable court as to whether they are following the procedure laid down by the ministry. Because the central government, after R.K. Sabharwal's decision, has come up with the 1997 notification and that has been circulated across all universities, central universities. And the UGC has also laid down its guidelines. And the parliament has laid down the law that the entire central education institution has to be considered. as one.
Now, one thing, how are they going to make a post-based roster if you cannot reserve a particular post departmental wise?
Lordship, the entire guidelines are there. The guidelines have already been provided to the university. The university has to work on the roster and then classify. But it
If
has
you
to be
impact
taken
the
as
voter-
one unit.
Huh?
The university has to be taken as one.
One unit. Anyway, yes.
Lordship's model roster has already been prescribed in the 97 office memorandum.
Uh-huh.
And my learned colleague supports my case. In the affidavit, they say that the post-based roster has applicable and has to be followed.
Okay, if it is post-based roster, can the post be reserved for a particular
Lordship, for a
category?
subject, Lordship, that is for the authorities to decide, because Lordship, if it is subject wise, definitely Lordship for a subject, Lordship, for an example, if I take Lordship, a particular subject of biotechnology, Lordship, it not be required that there has to be 10, 12 assistant professors. There might be a limited number of persons. They will have to squeeze and have to specify that the total number of these are there. Particular cadre will have to specify that in this post there are only two. Here, Lordship, we never come to know how many posts are there. Nothing is specific, but if
Anyway, the post-based roster cannot be made subject-wise.
subject wise, it would be.
Cannot
I
be done.
cannot say
Cannot
on
be
that.
done. I don't
Cannot be
think how will you do it? Otherwise, if there is only one
One
subject,
post.
one post
Then it
with
comes
one
to-
subject, then only
that
one
cannot be-
particular
It would
category,
involve-
then that cannot be.
Correct. Correctly, Lordship.
But anyway, the fact is that they have anyway made it for OBC. They're
Yes,
only,
that-
so whether they do it for SC or OBC, that the issue is
Basis this
correct.
particular categorized.
Correct,
That has.
correct, correct.
Reduced.
Correct. So I think that is the only thing,
I'll put it as subject wise, subject.
subject wise.
No, no,
Allowed it
no,
to
no,
be a
what's it?
different
We
customer.
work out in the entire department.
You bring out the entire post-based
Yes,
roster.
I'll put-
Entire, you have to bring the entire post-based roster. And then since you see, as it is, the sanction strength is 258. So the, what roster point will you follow? 100,
200 point.
200 roster point. How many, can it go up to 300 also?
Lordship, it can do.
400 also.
They determine the strength.
So it'll have to be, so if it is, so if the sanction strength is 258, it can be a 258 roster point.
Can be,
Can be.
because Lordship,
250.
30 points would be earmarked, Lordship, in that case.
So that'll be easier.
I'll produce tomorrow.
I don't think so. It'll be okay.
I'll get it.
Lordship,
Unless you can make it, you can make the roster point by tomorrow.
No, it is there already.
Is there?
It is already there.
Oh, very good. And that's,
Lordship,
Okay, there-
otherwise there
there-
can
there
be a
was a-
direction to follow the mandate of 1997 in terms of how they will prepare. Then they will proceed with the advertisements, Lordship. It will be very much precise and it will be helpful for the entire index, Lordship, the.
but then supposing they go again with the OBC, then you say that where is that? You'll want it again.
With the OBCs, it's okay, Lordship, because they have earmarked the post that OBC also comes into play, because it's a direct recruitment. In promotion, OBC don't get it. Only in recruitment, Lordship, OBC come. So, Lordship, even that.
No,
is
let
taken
them
care of.
bring it tomorrow if they
Maybe
can.
we'll
bring it.
try
If they can bring it and they can show
Sure, Lordship.
that
Sure.
the post that has been advertised
Correctly, Lordship.
is really for the OBC, then it's enough.
Maybe,
Yes,
If
my
it's for you, it'll go for you.
not so.
But I don't know if it can be done subject wise. That's another issue.
No, it is there, lots of, because
Subject wise.
there was some mistake was there in my affidavit. I'll get it tomorrow, by today itself, and I'll produce tomorrow.
Okay, right.
Lords, can I
Heard.
have my instruction of my senior lordship, Mr. D. K.
Huh?
Das? Lord, tomorrow also, Mr. D. K. Das would be here. I'll have some other. I'll just have instruction, lord. If not, it can be on Tuesday, lordship. If it's lord, if my lord is convenient. I'll just have instruction.
We'll do it tomorrow itself. Just wait, let me write down a little
Lots,
bit, otherwise I'll forget. Heard, Mr.
H. Bitala, lordship.
H. Betala, learned counsel for the petition. Also heard Mr. S. C. Kyal for the Assam University. Miss
Dr. P. Agarwal.
Dr. B. Agarwal,
P.
P. Agarwal. Who's your father? Is some lawyer? No, oh no. I was thinking that, no, okay. Dr. P. Agarwal, for the UGC, for the UGC. Mr. Okay. Okay, so your father-in-law not a lawyer.
No, Lordship, I'm a first generation lawyer.
Okay, very good, very good. Okay, right. Where is that advertisement that you put to
Lordship,
challenge?
16/12/2020.
Page?
I'll just.
Unless I write down all this, I'll forget by tomorrow everything.
230 page number.
13.
13, lordship, 213.
The petitioner has put to challenge the Assam University rolling advertisement number 3/2023 dated 6 July 2023 on the ground that the reservation that is to be implemented on the basis of the judgment of the Supreme Court in R.K. Sabharwal and others versus State of Punjab and others reported in 1995 2 SCC 745 has not been followed. The petitioner's counsel submits that,
Lordship, may I take leave? I have to.
okay, yes, the reservation that is to be implemented in terms of the rolling advertisement number 3 of 2023 requires post-based reservation and not a vacancy-based
Resolution.
reservation. Post- Next para. The petitioner's counsel, the petitioner is a
Assistant.
SC candidate
Yes.
who is desirous of participating in filling up the vacant post of assistant professor biotechnology. Pusta. However, the rolling advertisement number 3 of 2023 has advertised the filling up of the post of assistant professor biotechnology by an OBC candidate and not a SC candidate, which is a total turnaround from the decision taken. Where is that?
Lordship, 222 page.
222 turnaround from
Page 222, Lordship.
the what is this? From the resolution.
Resolution also, meeting resolution.
Meeting from the resolution
Starts at
passed in
158,
passed in
158.
agenda number item number 13.
Item number 13
Item 13
of page 214, Lordship.
in the
158 meeting,
in the
200. 158
Me-
meeting.
me-
of the Executive Council.
Assam University meeting minute 158 meeting minutes of the Assam University dated 14/8/2023. Full stop. In the 158 50 meeting minutes of the Assam University dated 14/8/2023, it had been decided that pursuant to the order passed in pursuant to the order dated 14/6/2023 passed by this court in WPC 7077 of 2019, the vacant post of assistant professor biotechnology would be filled up by an SC candidate. Gustav, however, the same has not been done. And the same has not been done. Full stop. Next part. The petitioner's counsel submit that the the Assam University would have to show the
Post earmark.
post-based roster point that has been made by the university for coming to a decision that the post of assistant professor biotechnology is to be filled up by OBC in terms of the rolling advertisement number 3 of 2022, which is at variance with the resolution passed in item number 30 in the 150th meeting minutes of the Assam University dated 14/8/2023, wherein the said post was to be filled up by a SC candidate. Next para, Mr. SC KL, learned counsel for the Assam University submits that he will produce the roster base what? The post-based roster tomorrow. Tomorrow, no? He said, this is the matter tomorrow. Acha, one more thing, you're right. Miss Dr. P. Barwa. P. Agarwal, the learned counsel for the UGC submits that in terms of the Central educational institutions bracket reservation in teachers cadre bracket close act, comma 2019. Hereinafter referred to as the 2019 Act.
Section 3, subsection.
Section 3 bracket 2 provides that for the purpose of reservation of post, comma, a central education institution is to be regarded as one unit. And that in terms of section 2 bracket L, the teachers cadre means the class of all teachers of a central educational institution, comma, regardless of the branch of study or faculty, comma, who are remunerated at the same grade of pay, comma, excluding any allowance or bonus. That's all.
And that post-based roster is supposed to be followed.
Full stop. She also submits that post-based roster has to be followed by the university for filling up the vacant post of assistant professor. So we'll take it up tomorrow. Let's see. That's the only thing. So if it's not there, then that means we have got to direct the university to prepare a roster and then thereafter,
Continue with the advertisements.
in a way, yes, of course, what you're doing is for the benefit of everyone,
Lordship.
but then you can only actually
But the Lords and
look
the
after
judicial
your.
review can come up with these issues. Lordship, this is not.
Anyway, but you see, that is,
Lordships can do it. Lordship.
it has to be clarified.
About
Otherwise, this is going to cause problem later on,
Correct.
unless you do it.
That is the big issue.
Yeah, you put this. This and this and this. Okay.
Deeply obliged. Much obliged.
ऑर्डर शीट तो लगा दो पेपर दिन में अपना देखना